Pardon my one juvenile bail my lord. Criminal revision. And another tied matter your lordship matter. Conviction matter for condonation of delay my lord. 10 days delay. Tied up matter my lord.
Lordship, BLAPL 11483. In this case, Lordship, when your Lordship previously heard the matter, there was an explicit direction that the matter was to be listed in the second week of December. However, it was not listed, and subsequently on first week of January also the matter was supposed to be listed. That has not been listed. Obliged, Your Lordship.
But criminal division number 626, 627, 628 matter. Up here the case it was posted on so like the other recommencement.
But for those criminal revisions have been filed.
Juvenile matter.
Give it, please.
Pardon to mention, my lord, petitioner's wife is suffering from cancer, carcinoma. That's why IA has been filed and it was.
Tied up bail.
Madam, criminal division 502. 27/2023 लास्ट डेट सर डायरेक्शन
What is the criminal revision?
CRLRB 527/2023
What is that criminal revision?
सर এটা against the CBI special court order against enforcement director PML under PML
That's it. Item matter. BL number is 4262.
Bail application.
After vacation.
Give it.
Criminal listing.
Criminal appeal for criminal appeal minor, convicted minor under the SC Act.
Give it.
I may beg and to mention this, sir, my lordship. The mother of the petitioner is not in deteriorating health condition of mother of the petitioner. I want to mention this.
Pardon to mention, my lord. My lord, may I mention BAPL number 7166 of 2023. My lord, the petitioner is JC since more than 3 years. The medical condition of the wife is critical, my lord, and there are 2 minor children. There is no one to take care of. My lord, in supplementary list, my lord.
Yes, next.
All right, my lord.
Item number 1 for delegated order is IA 7326 of 23 of 306 of 2020.
In view of the settled position of law that the demand of gratification and acceptance made by a public servant has to be established beyond a reasonable doubt without conducting a detailed analysis into the merit of the case. In the factual scenario, it prima facie appears that the observation of the London Trial Court in para 11 of the impugned judgment that the prosecution has been able to prove both previous demand and instant demand by the petitioner is against weight of evidence on record. Therefore, I am of the humble view that the petitioner has made out an exceptional case for grant of stay of conviction, and thus, if the impugned judgment of conviction is not stayed or suspended by the time the appeal is taken up for hearing and decided finally, much water will be flown under the bridge, and the evil that would likely to befall on the petitioner in the meantime would aggravate, and it would be too late to set the clock back, and it would cause irreparable loss and injury coupled with irreversible consequences resulting in serious miscarriage of justice to the petitioner. Accordingly, the order of conviction passed against the appellant petitioner by the London Special Judge Vigilance Cuttack in TR case number 62 of 2011 is stayed or suspended pending disposal of the appeal the IA is accordingly allowed.
Urgent certified copies में मैं
Yes.
I may pardon to mention item 80 minor.
Hmm?
Item 80.
Hmm.
In this case, the applicant was released on interim bail minor. He has already been surrendered in time manner. Took time to file a surrender certificate man.
80.
80. Surrender certificate not filed minor.
You have surrendered.
Minor, I have already surrendered.
Item number 80. The London Council for the appellant submits that he has instruction that after availing the interim bail period as per order dated such and such, the appellant has surrendered before the London trial court, and he may be given some time to produce the surrender certificate. Put of this matter in the week commencing from 5th of February 2024. Surrender certificate will be filed by the next date.
Item 2.
May please, Your Lordship. The appellant challenging the judgment dated 30/5/2023 my lord, annex of 4.
Yeah. Date asuni. କୋର୍ଟରେ ଆସୁନି ନା ଏଠି ଆସୁନି? CPC କୁ ଜଣା ହେଇଛି? Yes.
My lord, the appellant challenging the judgment dated 30/5/2023 my lord, under annex of 4 my lord.
What is the page number?
Page 113 my lord.
113.
113.
And the operative parties?
Internal page 37.
37.
Yes, 149 is the running page. Internal page 37 of the.
The Lord trial court my lord has held guilty for the offence of punishable under section 366, 323, 342, 376.
So it's the highest punishment is 7 years. All right. Hard admit call for the trial court record. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Deposition copies of the witnesses be supplied to the London Council for the state in the meantime.
Item 3.
Item 5.
May I please, ma'am? Running page 56, judgment page 44, my lord. Running page 56, judgment page 44.
Yeah.
Last lines, my lord. The convict is accordingly sentenced to undergo RI for a period of 3 years and to pay a fine of rupees 10,000 for each of the offence under section 7 and 13(2) of the PC Act, my lord.
So it is 3 years.
Well, 3 years.
And you are on bail during
Yes,
that.
yes. Cause title shows your lordship kindly see the judgment cause title. He was arrested and released on bail. Page 14, judgment page 2, my lord. He was arrested on 29/11/2014. Date of release on bail 8/12/2014.
Yes, copy has been supplied.
Yes, yes. Copy has been sought. That is why the matter is listed.
Where is Mr. Das?
He's here.
Mr. Das, you have received the copy.
Yes, my lord. I have received the copy. I will file my appearance memo by the end of April, my lord. And
Admit call for the trial court record. Mr. Sanjay Kumar Das, running standing counsel for the Vigilance Department, submits that he will file his appearance memo by end of so and so. He was on bail, bail allowed, stay realization of fine, name of so and so be reflected in the cause list as well as in the top of the brief henceforth. Free copy of the order be handed over to Mr. Das.
I have filed a miscase for stay of judgment. My learned senior may file objection thereafter.
IN number 65 of 2024. This is an application for stay of judgment and order of conviction. The learned counsel for the standing counsel for the Vigilance Department 4 weeks time.
for 6 weeks, my lord. 6
weeks time to file objection to the interim application. Put of this matter on 6 सप्ताह पर डेट दीजिए. Yes.
May I pray one thing, my lord? May I pray copy in course of the day because 30 days expired today, my lord.
Yes, is that.
Oblige.
Free copy of the order, my lord.
Yes, yes.
Oblige.
Item 6. Item 7.
May I please, your lordships? I am appearing before PROCEEDINGS.
Yeah.
May I please, your lordships? The petition appellants are challenging the order of dated 23/11/2023 passed by the Land Special Judge SCST Baleshwar, where they reject the bail application of the appellants.
Just a minute. The notice is sufficient.
My lord, on 10/1/24.
And you have received the case diary.
Yes, sir.
Okay. Mr. Behra, is it your first application or earlier rejected?
Start bail application before your honors.
So, what is the date of custody?
Date of custody, my lord. Uh, 13/11/2023 for appellant number 1 and for appellant number 2 17/11/2023. They are languishing custody since more than.
Charge sheet submitted?
No, my lord.
Yes, what is your instruction? Charge sheet submitted or not?
No, sir. Charge sheet has not been submitted yet.
What are the offenses here?
307 is the principal offense. And all the injury report, I have annexed the injury report of the injured persons from annex of 3 of the swelling and abrasion. All the injured persons have sustained the swelling and abrasion only.
There are how many injured persons?
7.
Hmm?
7.
Seven injured.
My lord. One of the injured person has serious injury.
Who is that injured?
Kumar Murmu.
Kumar.
My lord.
Kumar Murmu.
KUNAS.
My lord. Kumar Murmu.
Kumar Murmu has sustained grievous injury.
मतलब fracture
Fracture of
process लिखा है
what is his statement? Who assaulted him?
मतलब Kennedy pass over से बात करना
A grievous injury on what part of the body?
Hand, right arm.
Have you annexed that statement of Kumar Murmu?
Yes, my lord.
Okay, let us see that. Kumar Murmu, yes. Who assaulted him according to his statement?
The statement, all the accused persons having 7 to 8 persons, while he guard the stand query, all the accused persons unanimously assaulted him.
There is no specific overt act against you.
No, sir. My lord, in the meantime, Kumar Murmu has appeared before the land court, and the accused persons, namely Balaram Rao and Nitai Rao, have already released on bail. On 20th December 2023. They have already released on bail. And
who are those co-accused persons?
Balaram Raut and Nitai Raut. Kumar Murmu appeared before the land court.
What that Kumar Murmu said on appearing before the Land
while land court asked him as to whether any problem to release of the accused persons, accused persons, he stated that no, my lord.
Yes, Mr.
Yeah, my lord, I have the statement of Kumar Murmu.
Kumar Murmu statement I have seen that is annexed also, page number.
The second petitioner, Jaykrishna Pal, ଲାଷ୍ଟ ଲାଇନ୍ ସେହି ସମୟରେ ଜୟକୃଷ୍ଣ ପାଳ ଅଶୋକ ବାବୁ ପିନ୍ଧିଥିବା ସୁନା ହାରକୁ ଛିଣ୍ଡାଇ ନେଇ ତାଙ୍କ ମୁଣ୍ଡକୁ ମାରିବା ଉଦ୍ଦେଶ୍ୟରେ ଠେଙ୍ଗା ଉଠାଇବାରୁ ସେ ତାଙ୍କର ଡାହାଣ ହାତ ଦେଖାଇଦେବ ଠେଙ୍ଗାଟି ତାଙ୍କ ହାତରେ ବାଜିବାରୁ ଫାଟି ପ୍ରଚୁର ରକ୍ତସ୍ରାବ ହେଉଥିଲା। And so far, this present petition is concerned by the petitioner one, ମୋର ତଳି ପେଟକୁ ଶକ୍ତ ଗୋଇଠା ମାରିছে।
Okay. Heard the learned Mr. Badal Kumar Behera, Land Counsel for the appellants, is appearing through virtual High Court at Balasore. He submits that the appellant number 1, Rajesh Das, is in judicial custody since 13/11/2023. And appellant number 2, Jaykrishna Pal, is in judicial custody since 17/11/2023. An investigation has been made substantial progress. And out of 7 injured persons, only 1 injured, Kumar Murmu, has sustained grievous injury on the hand, whereas the other 6 injured persons have sustained simple injuries. He further submits that no specific overt act of assault has been attributed against the appellants, and the allegations are omnibus in nature. 2 of the co-accused persons, namely Balaram Raut and Nitai Raut, have already been released on bail. And therefore, the bail application of the appellants be favorably considered. Learned counsel for the state placed the statement of injured Kumar Murmu and also the injury reports कर देंगे. Anything about the criminal antecedents?
No, my lord. There is no criminal antecedent at their back.
Nothing adverse.
The Land Counsel,
Rajesh Das is concerned.
the Land Counsel for the state further submits that he has received instruction that the appellant number 1, Rajesh Das, has no criminal antecedent. Considering the submission made by the Land Counsel for the respective party, nature of accusation against the appellant, nature of injury sustained by the injured persons, absence of any specific overt act against the appellant, release of the co-accused persons on bail, and period of detention of the appellants in judicial custody. I am inclined to release the appellants on bail allowed.
Hello.
Item 8. May it please your lordship, I am appearing on behalf of Mr. S.K.SAHOO. My lord, the offences charged are 294 and 506 of IPC, and SC/ST Act is there. That is Section 3 of SC/ST POA Act, and 25 and 27 of Arms Act. My lord, the charge sheet has been filed, in which the 25.
Notice was issued.
Yes, notice submit.
You are appearing. So, what is the date of custody?
My lord, it is 7/11/23. It's been 2 months and 15 days.
7/11/23.
Yes, my lord.
Charge sheet submitted.
Yes, my lord.
Under what offences?
Under 294 and 506 of IPC, 31R, 31S, 32VA of SC/ST POA Act.
32
VA.
Any criminal antecedent?
Yes, madam. Two criminal antecedents.
Two criminal. What are the offences?
Offences are, your lordship, 294, 457, 380, 506 with 3 SC/ST Act, and another is also 294, 506, 3 SC/ST.
Is what do you say? Where is your VNAMA? Awesome.
Second is one case.
My lord, in both the cases, he has been released in bail.
So why are you repeating the crime, misutilizing the liberty that has been granted to you in
My lord,
cases? What is your good name?
Miss Saheli Satyarupa.
Give it in sleep. Pardon me, so and so, land counsel for the appellant, land counsel for the state, and Mr. Santosh Kumar Mahanti, land counsel for the informant, who has entered appearance today by filing VNAMA in court. Considering the submission made by the land counsel for the appellant, that the appellant is in judicial custody since 7/11/2023. He has been charge sheeted under Section 294(506) of the Indian Penal Code, Section 31RS/32BA of the SC/ST Act, and submission of the land counsel for the state that there are two criminal antecedents.
Sorry, madam, one criminal.
One criminal antecedent against the appellant, and for the submission made by the land counsel for the appellant that in the said case, the appellant has been released on bail. I am inclined to release the petitioner.
And I'm
appellant.
giving a copy of the CA. I'm giving a copy of the CA. I have this
copy of which is filed and taken on record. You see here, yes, allowed.
Obliged, my lord. Item 9.
May I please, your lords? Alleged offence, my lord.
Item 10.
May I please, your lords?
In view of the Pradhan Jani judgment, my lord, same affair earlier disposed of by my lord Justice P.P. Rautray. First, that was CR number 610 of 2019, my lord.
What is the number you said?
610 of 2019.
Rahul and counsel for the petitioner submitted that in connection with this case, number of applications for bail have been filed by different accused persons, and the bail application of co-accused persons Nirakar Swai, Sunil Polai, and Yudhishthra Das.
Yudhishthra Das is the informant.
Acha, Sunil Polai in CRL number Dijon, Nirakar Swai and Sunil Polai. In CRL number 16 of 2019 have been disposed of on 4/3/2020 by Honorable Justice B.P. Rautray. And prior to that, though some bail applications have been rejected, have been disposed of by other honorable judges, but all of them have retired. And therefore, in view of the your standing order, so and so, the matter is to be placed before Honorable Justice B.P. Rautray. In view of such submission, registry shall take steps for listing this CRL before the appropriate bench.
Oblige.
Item 11.
Item 11, may I please?
Item 12.
May plus minus. SCST appeal only 506. My lord and senior is appearing on behalf of the.
The OP number 2. CRLA means it is
SCST.
okay.
Minor offenses
Where
506.
is your VNAMA?
That is today I am filing. I'll keep it day after tomorrow.
नाई की वकालतनामा आप
No, अच्छी.
आप 506 से कहीं रही
As your sign filing.
दियंतु भाई अच्छी दी दियंतु ना लिखी दो जी वो VNAMA फाइल कर दो के बेट रोइलैंड
4/12/2023.
So also files VNAMA for the opposite respondent number 2, which is taken on record. Considering the submission made by the learning counsel for the parties, nature of accusation, the period of detention of the petitioner in judicial custody since 4/12.
Yes, ma'am.
4/12/2023 and progress of investigation. I'm inclined to release the appellants on bail.
I'm just
Public.
Item 13.
May I please, your lordship? My lord, SCST appeal earlier. My dear lordship has directed the state to obtain instruction regarding issue of process against the petitioner or not. My lord, here I got instruction and that NBW has been issued against me. My lord. So
yes, Mr. Kipad.
No, 80 to 83%.
No. So what are the offenses under which charge sheet submitted?
my lord, charge sheet submitted under section my lord 409, 457, 474, 34.
Just go slowly. 457,
474, 34 of IPC. My lord.
So what is the allegation against the present petitioner?
I was the
CD not there.
I was the assistant branch manager, my lord. And all the allegation against the branch head. And my lord, here is the informant. Trial has been commenced and informant Ajay Kumar Lenka have been examined and he clearly stated that after audit inquiry, accused Sachin Pradhan who is the branch manager, my lord, admitted his guilt and prayed for some time to repay all the default amount. That is, my lord, in my para 12 of my petition, I have mentioned it. And he has also said that the present petitioner, as the in a position of assistant branch manager, has already has already given a letter to his superior senior officers regarding the irregularity made in the branch.
Where has he stated?
My lord, that is, I have mentioned, my lord.
There is a PW5 deposition is there.
PW5 depositions.
Where is that?
Last page.
You have not given any deposition. एक किसी deposition दीजिए
हाँ, deposition दे दीजिए. My lord, that is an annexure.
No, PW5. Okay.
Annexure 12, my lord.
So,
13 to 17.
Sabitri Pradhan was working as assistant branch head at Nachuni branch, right?
Yes, my lord.
Audit was made. Audit report reveals 32 packets of gold. Those were 21 packets of gold missing, 7 packets having spurious gold, 3 packets having mismatched items. So after audit inquiry, accused, namely Sachin Pradhan, admitted his guilt and prayed for some time to repay the default amount. As the accused could not pay so the main company instructed me to lodge the FIR. No, that's all right. What is there in the audit against you?
Nothing, my lord.
Have you got the audit report?
No, my lord, I have not.
Look on the Learned Counsel for the state has produced written instruction from IIC of Banpur police station, which indicates that no processes under section 82 and 83 CRPC have been issued against the petitioner Sabitri Pradhan. The written instruction is taken on record. Land Counsel for the petitioner submitted that the trial has commenced in respect of the co-accused, and during course of such trial, the informant Ajay Kumar Lenka has been examined as PW5, and he stated that the accused Sachin Pradhan was working as the branch head of Manapuram Asset Finance Limited, Khurda. And the petitioner Sabitri Pradhan was working as assistant branch head at Nachuni branch. A branch head माने कोठी कर नाचुनी branch और ये
Nachuni branch.
अच्छा सेटा खुर्दा न लिख दियो branch head of Manipuram Asset Finance Company at Nachuni branch, and the petitioner was working as assistant branch in the said branch. And after audit inquiry, the co-accused Sachin Pradhan admitted his guilt and prayed for some time to repay all the default amount. And since it could not be repaid as per the instruction of the company, FIR was lodged. The Learned Counsel for the state seeks some time to obtain the case diary and particularly the audit report. Put up this matter on such and such date, taking into account a submission made by the learned counsel for the petitioner that the petitioner is a lady and keeping in view the proviso to section 437(1) CRPC as an interim measure, it is directed that the petitioner shall not be arrested in connection with Banpur PS case number 82 of 2022 till next date.
Shall I
5th
play something?
February 2020.
Let him give all the deposition copy. Which,
Deposition copies of the rest of the witnesses be handed over to the learned counsel for the state in the meantime.
Obliged, man.
Item 16. Seventeen.
Present bill application, my lord, arising out of the order dated 15/1/2021 passed by this honorable court. Your Honor, in this matter, the expeditious order has passed for the conclusion of trial within the 1 year of the period, ma'am. And now till date, out of 66 witnesses, the only 19 has examined, and the accused, who is innocent and guilty, and still he is in JC, Your Honor, since 25th of February 2019, Your Honor. At this stage, Your Honor, the family of the petitioner applicant, the one wife and two kids.
Earlier the bail application was rejected.
Please, madam. At phase 95 of this bail application, the order passed by this honorable court on 15/1/2021 on the last paragraph on page 96 and 95 last, the trial court shall do well to conduct the trial within a period of 1 year from the date of receipt of the copy of this order, if there is no other impediment. Accordingly, the bill stands disposed of, Your Honor. As per the direction of this honorable court, because of the heavy cause list or any other reasons, the trial has not to be concluded within the period of 1 year. But the petitioner is, Your Honor, since on jail in 20.
Yes, Mr. Naik.
Whatever the conditions may impose, Your Honor, I am avoid for that.
Your lordships had dismissed the bail application on merits. That when it came, your lordships had targeted it. When the trial could not be concluded in that period, your lordships had called for a report, and your lordships had made it quite clear at that point of time there is no question of revisiting on the merits of the case because a detailed order was passed and there was no change in circumstances. And in the meantime, your lordships, witnesses were not getting examined, but now they have started.
That about 19 witnesses have been examined.
Yes.
And what is the total number is 60?
66.
66. This man is from Bihar, Mr. Naik.
Yes, your lordships. And he was
So-
absconded. If your lordships will see the original order, that's a very, very detailed order. Even though the co-accused were released on bail, your lordships, at that point of time, while disposing of the bail application rejecting, your lordships had categorically stated that parity is one of the ground, it is not the only ground. Just because somebody else had given him bail, no Article 14 is available to him, because his conduct was such that your lordships, he was absconding for a long period of time. With much difficulty, we had arrested him. If your lordships had that order, rejection order.
It's the case of the year 2009.
Yes, your lordships.
And
But
he was taken into custody in 2019.
Yes, Lord. 10 years he was absconding, your
10
lordships.
years absconder, okay.
Yes. But with very much difficulty, we had arrested him. And if your lordships will read the rejection order, it's a very detailed order, your lordships.
No, whatever, but so far, this 19 witnesses evidence has been recorded. What has come against this present petitioner?
Nothing, madam. And
your lordships, I'll file a copy of the depositions of all the witnesses examined.
He has not filed.
no, already filed. Already filed. Served also copy.
He has stated that he has served a copy on you.
No, your
So
lordship.
he says that 19 witnesses have been examined and it has been served upon you. Please verify whether from these 19 witnesses statement anything is brought out against this petitioner.
Yes, your lordships.
It's a case where the assurance was given for giving them job and some amount was taken. That is the case, na?
Yes, yes, your lordships.
Okay.
Lordship.
That was perhaps in railway department or something like
Yes,
that.
your lord.
Please,
yes.
So please verify if you have got whether anything has been brought out on record. Number 2, about the criminal antecedent, have you got any instruction in that respect? And whether third thing is that whether the address furnished by the petitioner in the cause title, that is correct one or not. These 3 things to be verified.
Yes, your lordships.
We take up this matter next
my
week.
lord, my lord, please at this stage, my lord. At this stage, my lord, please. I am not the named.
Let him go through the evidence.
Please.
Your lordship.
Mr. Naik, you have received the copy of deposition.
Yes, your lordship, have received it.
Okay, just go through it and take these 2 instructions about the CA and whether the address furnished in the cause title is correct or not. Okay.
And in deposition, if somebody has told something about
Yes,
him or not.
right. That is why I wanted that you should go through it and see whether anybody has stated anything against this present petitioner or not. All right. Hard the Learned Counsel. What is your good name?
R.R. Singh.
Mr. R.R. Singh, Learned Counsel, appearing for the petitioner, and Mr. Sarthak Naik, Learned Special Public Prosecutor for the CBI. Mr. Singh submitted that when the petitioner appealed this court for bail last time in BLAPL number 2293 of 2020, as per order dated 15/1/2021, while rejecting the application for bail, this court directed the Lennon trial court to expedite the trial and to take all possible steps to proceed with the trial on day-to-day basis, keeping in view Section 309 of CRPC. And there was a further direction to conclude the trial within a period of 1 year from the date of receipt of the copy of the order, if there is no other impediment. Learned counsel for the petitioner submitted that he has instruction out of 66 charge sheet witnesses. Only 19 witnesses have been examined so far. And he has supplied the deposition copies of those 19 witnesses to Mr. Naik, which is not disputed by the Learned Special Public Prosecutor. Mr. Naik, however, submits that this case is of the year 2009, and the petitioner, with much difficulty, was taken into judicial custody on 25 to 2019, and therefore he was an absconder for about 10 years. However, he seeks some time to go through the deposition copies of the witnesses examined in the trial court to verify what role has been attributed against the present petitioner by those witnesses. So also to verify if there is any criminal antecedent against the petitioner and whether the address furnished by the petitioner in the cause title is a correct one or not. Put up this matter next week.
At this stage, my lord, take my one submission. Actually, I am not the named FIR,
A free
and
copy of that will be hard.
my name is
A
disclosed.
free copy of the order be handed over to the copy be handed. Yes. Next.
My lord, if the date fix as per my convenience, because I am coming from Delhi.
No, it will be on a, don't come argue on virtual mode. No, there is no necessity to appear in physical. Yes. Yes, item number 18.
May I please, my lord? My lord, I am in VC, my lord.
Yes, Mr.
May I please, my lord? I am in VC, my lord.
Yeah.
My lord, offense under 20B 2C 27A 29 of NDPX Act.
Well, let's say these are. No, you are supposed to
Address statement will be
obtain instruction about the whether the address furnished in the cause title is correct one or not, because he is a man from Uttar
UP,
Pradesh.
my
And there was a direction to the SP Malkangiri to make necessary communication with the SP Agra district in the address.
We send the letter. I will take instruction. That's it.
This matter came on 5/1/2024.
I've sent
So the letter has already been sent.
I have sent on
The
9/1.
instruction is awaited. Okay. Put up this matter next week as prayed for by the London Council for the state in order to obtain instruction as per the order dated 5/1/2024. Yes.
no, please tell.
Item 19. Item 20.
May I please, your lordship, my lord? Petition is in custody from the 19th December 2020, my lord. Last occasion, lordship, direct attack into the status report.
Just a minute. Just a minute. Wait. Where is the status report? Okay, the report is that out of 24 charge sheet witnesses, 13 witnesses have been examined. So he has sent the deposition copies. Anybody has stated against you?
No, my lord. All the witnesses are hostile. I have last occasion submitted the certified copy. And also further, I have all the certified copy. Lordship directly another witness, the email Irma. He is also hostile, the PW number 12.
This is the first application or earlier rejected?
Earlier, my lord, withdraw and file after.
What is your earlier bail application? How many petitioners are there in this application?
Earlier,
There are 4.
One co-accused was released on bail by your lordship, my lord.
No, just a minute. As it appears, there are 4 petitioners.
Yes, my lord.
So, earlier bail application of these 4 petitioners was withdrawn.
One was written already, and another application was allowed by your lordship, my lord.
ମୁଁ ଏଇ ବେଲ୍ ଏଇ petitioners ମାନଙ୍କ କଥା କହୁଛି. ଆଚ୍ଛା. Now, since when they are in custody?
Yes, 19th December 2020, my lord.
19th December 2020. 2020.
My lord.
Charge sheet submitted under what offenses?
302 and 201.
302, 201 and 34. You submitted, Mr. Tripathi, on the other day.
Yes, Lord.
That 2 witnesses whose name are Debe Madhi and Email Irma are the eyewitnesses. But he says that Email Irma has been examined and he has not supported the prosecution.
Yes.
He had given last occasion 8 deposition. All were hostile. These 2 eyewitnesses were not examined that
No, Email Irma has
now
been
examined.
So now
Debe
only
Madhi-
remains that Debe Madhi, right? All right. Heard the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submitted that when the petitioners are in judicial custody since 1920. The earlier bail application of the petitioners in BLAPL number petitioner ତା ଦେହରେ କେବଳ ବୋଧେ ଗଙ୍ଗା ସେଠି ଥିଲା in BLAPL number 1492 of 2021. ଆପଣ ପାଖରେ କଣ ଅଛି?
ଆଉ ଗୋଟେ ଅଛି 1521 of another bail application Sodisuka.
That was
Sodisuka is not the petitioner here.
but
No,
that
he's
was
not
the
here to
first
petition.
application the lordship has allowed.
All right. That the earlier bail application of petitioner number 4 was disposed of. Have you got that order 1492 of 2021?
1521 of
1521 ରେ ପରା ଆପଣ ଏଇ 4 ଜଣ ଭିତରୁ କେହି ପିଟିସନର ନଥିଲେ ବୋଲି କହୁଛନ୍ତି.
and I have
That is
certificate also. 1492. 1492.
1492, yes, sir.
Yes.
Disposed of as withdrawn like them. That 149 to 2021 was disposed of as withdrawn. In the meantime, 13 witnesses have been examined, and none of them has stated anything against any of the 4 petitioners. And therefore, even though some of the eyewitnesses have been examined, and therefore the bail application of the petitioners may be favorably considered. Learned counsel for the state submitted that one Debe Madi, an eyewitness to the occurrence, is yet to be examined. As for the order dated 5/1/2024, the Learned Trial Court has submitted the status report, wherein it is indicated that out of 24 charge sheet witnesses, 13 witnesses have been examined. Considering the submission made by the Learned Counsel for the respective parties, since nothing has come out during the trial, even though the prosecution has come out against the petitioner during trial, even though the prosecution has examined 13 witnesses, including some of the eyewitnesses, and taking into account the period of detention in judicial custody, I'm inclined to release the petitioners on bail allowed.
Item 21.
May I please? Last my lord, that last occasion directed to state council to take instruction about the criminal antecedent matter.
No, you yourself submitted that he has got 12 criminal antecedents.
I have verified my lord.
Yes.
He has 16.
16.
Yes.
So get the rest 4 status about those 4 cases. Take those numbers from the Learned State Council.
Yes, ma'am.
Okay. Though the Learned Counsel for the petitioner filed comprehensive affidavit in court on 5/1/2024 relating to the status of 12 criminal antecedents against the petitioner. The Learned Counsel for the state, however, submitted that the petitioner has got 16 criminal antecedents, and he supplied the 4 cases which are left out in the comprehensive affidavit filed by the petitioner on the last date. The Learned Counsel for the petitioner seeks some time to obtain instruction about the status of those 4 cases and file a fresh comprehensive affidavit in that respect. Put up this matter. Kebe rakhibi kuhନ୍ତୁ? Next week re na gote saptah pare?
Next week.
Okay, put up this matter in the week commencing from 29th of January 2020.
Old age.
Item 22.
My lord, I'm through virtual mode. Lordship, I'm through virtual mode. My lord, in this matter, my address has been verified as per the cause title. One surety document has already been verified, the last date of hearing Lordship had directed for the submission of one more surety document. I have sent it to my senior, learned S.C. Tripartisan. So the second surety verification was pending on the last date of hearing Lordship. And in this case, out of 8 accused, 2 are on the regular bail, 3 are on interim bail, Lordship.
Press surety document you have supplied to
yes,
the
Lordship.
council.
Yes, Lordship. on this month.
Verified.
What is his name?
No, he supplied two local sureties.
Yes.
Earlier, but one Modi Harijan, whose name he supplied, was found to be dead since 2 years.
Yes.
That's why he was directed to supply you the name of one fresh surety with his documents, and Mr. Manohar says
Bania.
Huh?
Sridhar Bania.
Sridhar
Benia.
Benia.
Sridhar Bania is not staying. There is no such person in that name.
Mr. Manohar, are you listening what Mr. State Counsel
Yeah,
said?
I am submitting that.
Report has come
Yes,
that
Lord.
person is not staying and his whereabouts is not known. He is not a person of that locality. So,
Lordship, I have got the documents from there only, and the Aadhaar card is also there.
the one surety is okay. So the problem is with another.
Yes,
surety.
Lordship.
So give a phrase name. You have given the name of
Yes, my lords.
Modi Harijan. Just a minute. Just let me.
Modi Harijan.
Modi Harijan is dead.
Dead since 2 years, and that is second time.
Second one. It is ascertained that the Modi Harijan died since 2 years, and on inquiry, it is ascertained that Sridhar Bania doesn't belong to village Usaguda. So,
Lords, my lord, this time the document which I have supplied is the Gopinath Harijan. Gopinath Harijan, to my learned senior, on WhatsApp number on date 8th of January, Lordship.
No, the Sridhar Bania document is also because he is not of that village, he is not staying there. So, in fact, you have to supply that. Have you got any further documents?
No, that is not there.
WhatsApp, to whom you
My
supply?
lord, my on the number of my senior, Tripathi sir. Tripathi sir. On 8th of this month. On 8th of this month.
WhatsApp. Check.
Gopinath Harijan. The document of Gopinath Harijan, Lordship.
Gopinath?
Harijan. Gopinath Harijan, and the Aadhaar number is 8596 2456 7893.
If it is supplied.
Harijan Lordship.
That and another person you are to supply, because Sridhar Bania is not now acceptable because he does not belong to that area and there is no such person by his name.
Lordship, one surety has already been verified. Second one was dead. So Lordship had directed me to submit one document. So I had supplied this document of Gopinath Harijan.
The report which was placed on that day, in fact, it was partly in that only stated Modi Harijan is dead. But it was not stated.
Yes, Lordship.
In that very report, it is mentioned that no such person by name Sridhar Bania at village Kosagur was residing. So that's why it could not be mentioned in that order. All I take down. The Learning Council for the state has produced the report dated 20/12/2023 of Inspector in charge of Mathili Police Station, Malkangiri, which indicates that the two local sureties whose names and documents were furnished by the Learning Council for the petitioner were Mudi Harijan, M-U-D-I, Mudi Harijan, and Sridhar Benia. And it was ascertained that Mudi Harijan died since 2 years back, and there is no such person by name Sridhar Benia staying at village Kosaguda. The Learning Council for the petitioner, though submitted that one fresh surety name and documents were sent to the WhatsApp of Mr. Tripathi, Learning Additional Standing Council. He submits that there is no such communication he has received from Mr. Manohar. Let Mr. Manohar supply the names, address, and documents of Press Local Surety to the Land Council for the state, on receipt of which instructions shall be taken about the genuineness of the surety, local surety karibe, and also the authenticity of the documents. Put up this matter. Go to Saptah pare. This report is taken on record. Yes.
Obliged, my lord.
Item 23.
May it please your lordship. Lordship, on the last occasion directed to supply the surety details. Lordship, wide dated 18/1/2024, I have supplied wide memo. One is Hari Haldar and one is Sujay Mandal. I submitted all the details.
Jodhpur district in the state of Rajasthan. Correctness of the address of the petition 1. Then supply the names and yes, what is your instruction?
The security verification received lately. I will send it.
What about the address verification? Because there was a direction that it is to be the SP Malkangiri has to make correspondence with.
Yes. Well, a letter has been sent, but no instruction received.
Get it, and we're taking up this matter next week.
Yes.
Land Council for the state submitted that as per the order dated 5/1/2024. Correspondence has already been made with the Superintendent of Police of Jodhpur district in the state of Rajasthan by the Superintendent of Police Malkangiri regarding verification of the correctness of the address furnished by the petitioner in the cause title, but report is awaited. And since the Land Council for the petitioner supplied the names and documents and address and documents up to local sureties little late, instruction is still awaited, and the matter may be taken up in some other day. Put up this matter in the week commencing from 5th February 2024. Yes. Free copy of the order be handed over to the land. Yes.
Item 24.
May I please, your lordship, my lord, here this is the application for modification of your lordship's order. Your lordships on 25/4/2023 kindly peruse that order, my lord. Passed the order directing the petitioner to release on bail subject to payment of cash security of 2 lakhs.
Cash security of
2 lakhs.
Yeah.
But till today, my lord, he could not able to. In the meantime, my lord.
You are still in custody?
My lord, still in custody. Trying his level best, but 50,000, my lord, I have specifically, my lord, taken now 50,000 he has, my lord, collected.
Yes, Mr. Tripathi.
Copy not, sir.
The bail order is dated on copy. Bail order is dated 25/4/2023. Since the allegation of cheating was 10 lakhs,
yes,
that's why there was a direction to deposit cash security of 2 lakhs, which he has failed to deposit even though more than 8 months have passed. Or the Land Council for the petitioner, Land Council for the state. Is an application for modification of the order dated 25/4/2023. The Land Council for the petitioner submitted that while releasing the petitioner on bail as per order dated 25/4/2023, this court imposed cash security of rupees 2 lakhs to be furnished by the petitioner apart from compliance of other terms and conditions for release on bail. However, on account of financial difficulty, the petitioner couldn't arrange such amount, and the petitioner is ready and willing to furnish cash security of rupees 50,000, and therefore the order be modified accordingly. Land Council for the state has no serious objection. Considering the submission made by the Land Council for the respective parties, the order dated 25/4/2023 is modified to the extent that in place of cash security of rupees 2 lakh, if the petitioner furnishes cash security of rupees 50,000 and comply the other terms and condition as per the order dated 25/4/2023, he shall be released on bail. IA is disposed of.
Pardon my lord. Item 21. The State Council which has supplied, it is another co-accused, but the present petition is another. Present petition is S.K.SAHOO. At the
Wait.
Let me read. Sorry, my lord. The Kushta Chandra has 12. Yes. Kushta Chandra has 12.
What number it?
Item 21, my lord.
21. 172 of 23.
So what comprehensive affidavit you have filed?
My lord, filed in present petitioner was arrested in Dhinkan PS case. All cases, most of cases was also granted bail, and some cases in the meantime he was acquitted, though he was custody since 2019, my lord.
In this case, you are in custody since when?
In this case, custody since 13/11/2019.
13,
11, 30.
11/2019.
19, my lord.
And
remanded.
What are taken on remand?
Remand.
And what are the offences under which charge sheet submitted?
Charge sheet submitted 394, 390.
Let the State Council.
Yes, my lord. 394, 397, 302, 25/27 abstract.
So what are the materials against the petition?
Only my lord, confessional of co-accused was arrested in
Some of the witnesses have been examined, it is stated.
one witness examined and another witness was declined.
No. When you see in the rejection order dated 22/12/2022, which you have annexed as Annexure 2, page number 12. There you have made a submission. You means you are the counsel who was appearing for the petitioner. He stated that in the meantime, some of the witnesses have already been examined by the prosecution, but they have not whispered anything. And then the court observed that the accused is facing trial under section so and so. And from the statement of so and so, it appears that so and so, you and another Jitu are actively involved in the robbery in the night of so and so. And statement of other witnesses indicates that due to assault at the time of occurrence, so and so sustained injury, subsequently died. So it appears that more witnesses have been examined, not one. So have you got the deposition copies of those witnesses?
I am the conducting counsel, and I also collected one witness who was examined. One witness who was examined.
PW1?
One.
Examined
on 16 September 2022.
No. ଜଣା ପଡୁଛି ଅଧିକା ହେଇଛନ୍ତି।
2022 ରେ ହଜୁର
ଗୋଟେ
ଗୋଟେ
କାମ କରନ୍ତୁ, ସେ ଯୋଉଟା
Status
ଆଗରୁ
report ଦଉଛି।
ଆଗରୁ ଲେଖିଥିଲେ ସେଟାକୁ କାଟି ଦିଅନ୍ତୁ। Learned and Counsel for the state placed the rejection order dated 22/12/2022, from which it appears that some witnesses have been examined in the trial court. However, the learned counsel for the petitioner submitted that he has instruction that only one witness has been examined. Since the rejection order, since more than 1 year has passed from the rejection order dated 22/12/2022, let a status report be called for from the Land Trial Court, and while submitting the status report, the Land Trial Court shall send the deposition copies of all the witnesses examined
Pardon me.
of this matter in the week commencing from 5th February 2024.
Pardon me. One thing. My lord, last occasion one co-accused order on dated 4/8/2023, my lord had called for the status report. On that report, only one witness examined. It
What
was
is the order
reflected.
dated?
4/8/2023.
Asu latest report asu.
Yes, ma'am.
Eta kit number hela?
21.
5/2/23. Status report and deposition copy.
Oh, yes.
Item 25.
Nihar Ranjan Sahu. Or there.
CDs.
CDB nahi. All right. Non-appears for the petitioner. The Land Council for the state seek some time to produce, seek some further time for them to produce the case diary and to obtain instruction about the criminal antecedent. Put up this matter in the week commencing from 5th February 2024.
He is not unmuted. Please.
Mr.
Muted.
Unmuted.
Was muted. Okay. No, they didn't mute us. Yes, go on.
My partnership item. My partnership item 25. Item 25. 25 CD asin na kon କହିଲୁ?
ନା CD ଆସିନି।
ଆସିଛି?
ଆସିନି।
address verification ପାଇଁ ଯାଇଥିଲା last time। ହଁ ସେ କରିନାହାନ୍ତି ସେ ତ କରିବେ next week 5th ରେ ରହିଛି। Yes. Okay. You received that non-appearance? Yes, non-appearance card.
Item 26.
My lord, may I appear? And I'm on virtual mode. This is the case, my lord, where he has been arrested in custody from 6/2/2019. According to the prosecution, he has probably 17 cases of the similar nature. And he has been granted bail in some, and some are now pending before my lord. Some interim bails have also been granted by other courts. Since these 17 are there, my lord, these 3 matters before my lord, now 7 are there. So 5 more matters are there, my lord, which I had given a list, it hasn't come. My lord, issue is here. He has been in custody for 5 years for allegations of 420, 406, and in one case 467, 468. In all these matters, he is in custody for 5 years. Some of them, my lord, he had given some cash surety was directed, he was not able to pay. My lord, the conspectors of the list.
What is this?
That he has taken money for the purpose of getting people engineering seats and couldn't get them. And they are the people who are people who have filed the FR, they are themselves habitual bribe givers.
This petitioner earlier approached this court.
Yes.
For bail in BLAPL number 10943, and
Yes.
This order was passed on 1/8/2023.
Yes, my lord.
And there was a direction to the learned trial court to expedite the trial and conclude the same within a period of 6 months from the date of framing of the charge. So, what is the status of the case now?
Status, my lord, 8 in some cases.
Out of 8 witnesses, only 2 witnesses have been examined.
No, when the charge was framed, because the direction was to conclude it within 6 months from the date of framing of the charge. So, when the charge was framed.
Yes.
Have you got the copy of the charge?
No, ma'am.
So, then how can it be calculated? When that PW1 was examined?
But 21, my lord, I think this one 9 charge sheets.
2012 22.
Who were examined?
No. Then
there are different dates, my lord. Charge has been framed in one case, that is
we are confined to this particular case.
Yes,
now
my lord.
Case number 2028 of 2020.
2028.
Mix it up. So go one by one. So GR case number 2028 of 2020. What is the position?
On 20/22 PW1 and 2 were examined. Out of 8 charge sheet witness, only.
Have you got the order sheet copy? Certified copy?
Order sheet.
Then it will come. They heard Mr. Yashovan Das, and senior advocate, appearing through virtual mode, who submitted that earlier the petitioner approached this court in BLAPL number 10943 of 2022, which was disposed of on 1/8/2023, and though there was a direction to the learned trial court to expedite the trial and conclude the same within a period of 6 months from the date of framing of the charge, but only he has instruction that only kete gote witness na kete,
examination.
but he has instruction only 4 witnesses have been examined. Since the learned counsel for the petitioner is neither providing the order sheet of the learned trial court nor the deposition copies, let a status report be called for from the learned trial court. It is pending in that JMFC UTP Cuttack.
Yes.
From the Court of Learned JMFC UTP Cuttack in GR case number 2028 of 2020. While sending the status report, the learned trial court shall also send the copies of the deposition of all the witnesses examined so far in the court, and receiving the same registry shall hand over a set of deposition to the learned counsel for the petitioner. So also another set to the learned counsel for the opposite party. Register judicial shall communicate the order to the learned trial court by 24th of January 2024 to do the needful. We will send the copies at an earliest put of the matter next week. Similar order. The other one also similar order was
Yes,
passed.
yes.
Okay. ता परटार मध्य say order passed next week ଆସିବ ହେଲା.
My lord, I had prayed, I had given the numbers of the 7 other matters, my lord.
This matter, this item 27, not faster like them. Mr. Das submitted that the petitioner has got similar cases and he has filed PLAPL number so and so. List these matters, 2 matters along with PLAPL number so and so, which is furnished by the learned counsel for the petitioner. ଆପଣ ଗୋଟେ signature ମାରି ଦେଇ ଦିଅନ୍ତୁ ଆଜିର date ବି ପକେଇ ଦିଅନ୍ତୁ. Mr. Nirmal Chandra Mahanti furnished a list of those cases kar diyantu in court. It will be listed. Yes, next.
Deeply obliged, madam.
Item 20. Item 27.
27 ଗଲା ପରା.
28.
ତାଙ୍କୁ copy ଟା ଦେଇ ଦିଅନ୍ତୁ ଯୋଉଟା list time ରେ. Yes, with the other କେତେ କେଇଟା case ଅଛି? 7ଟା. 7 cases.
In this case, my lord, petitioner inside custody, my lord, 25/11/2020.
Item number 28.
28, my lord.
You have received the case diary?
No, my lord, instruction received. That is IIFL matter that came along with the Lala Amritsar.
But in the meantime, my lord,
What order was passed? State submit section case diary. अच्छा case diary आपनको आइता आनिया ପାଇଁ status report मगाइतला.
that is my lord flag D, my lord.
Status report has been framed, and out of 142 charge sheet witnesses, 8 witnesses have been examined. So that order was
Inside custody, my lord, 25/11/2020. And in the meantime, my lord, 3 of the accused person already been granted bail by these two, my lord, before this honorable court and 1 before the apex court, my lord. That is my
your bail application was earlier rejected.
Rejected before your lord.
How many times?
That is it. 1 time, my lord.
What is that number?
That is, I have given the number in the certificate.
Certificate ରେ ଦିଟା number ଅଛି. କୋଉ number ଆପଣ କହିଲେ ଗୋଟେ?
Both number. Earlier 2 occasion.
So ఇది అబ్బలు ఇచ్చేసి order గుడాకు.
May I place 1 order? I have got 1 order.
या नाउ ची रंजन कुमार बेहरा.
Yes, ma'am.
BLAPL number 1942 of 21. तारो allegation code लिखा है जी को पेज रे ओटा समस्त इंडिविजुअली Ranjan Behera.
Allegation against the petitioner, some amount has been transferred to the account of the petitioner, my lord. By
Yes,
the my lord,
Ranjan Behera, page number 30. During course of investigation on the basis of the statement of accused Santosh Bhui, the petitioner was arrested on the basis of his confessional statement. Gold ornament weighing about 2 kg and 12 grams were recovered, which belonged to the company along with other articles. And it was identified by the customers of the company, namely so-and-so, so-and-so. Petitioner made criminal conspiracy with so-and-so by tampering. So,
And account transaction also.
So no, what you say that some of the co-accused persons have been released on bail
by
this court and also by the Honorable Supreme Court.
Coordinate.
Hand over the
coordinate benchman. Coordinate benchman. Before
whatever it may be, in this
before
court,
this
this
honorable
bench
court,
can-
two of the accused person, mainly one Saroj Kumar Putti, that is BLFL number 6922 of
receive the
2022.
bail order so that he will verify to see whether they stand in the. on
No,
the
they are
same
not same footing here.
Yes.
This is docket case.
Hmm.
He is the docket.
Hmm.
He has stolen 2 kg of 2 kg 12 grams of gold seized from him, and an account transaction of rupees 4,96,000 has been recovered.
That account has been freezed.
Freezed.
As per the rejection order, Lordship may kindly see how the petitioner implicated in this case.
Swaraj Prushti is different footing. That is it.
That is, my lord, on the basis of Lala Amrutsagar Rai, money has been transferred by Lala Amrutsagar Rai to the account of the petitioner, and that account has been freezed, my lord. And in the meantime, my lord, Saroj Kumar Prushti has been granted bail, and another, my lord, Satyam Pradhan, that also granted bail, and Lalit Soni has been granted bail by Apex Court, my lord.
No, you have
Nothing has been seized from them. Nothing has been seized.
So what he says that you stand in a different footing because about 2 kg and some odd gold was recovered from you. But that was not the case in respect of those 3 co-accused persons who have been enlarged on bail.
My lord,
What is your submission?
My submission before let's see. Only the basis of co-accused statement, the petitioner implicated, and the co-accused has given some petitioner not committed the docket, my lord. Some amount has been transferred to the account of the petitioner, my lord.
That is one part. Account transfer is one part, but the second part is that you gave those gold ornaments of 2 kg and odd that was seized from you.
And that is identified by the customer.
Is not identified by the customers. But such type of allegation was not there against the 3
other 3
persons who have been enlarged on bail. That is how he is making a distinction between your case and the case of the co-accused persons. What is your submission?
But I am inside custody, my lord, 25/11/2020. In the meantime, my lord, 3 years and
how many cases you have got?
I except this case, on the same transaction, another case has been 420 has been registered. The fact of the case, my lord, the employees of the company made a plan to took the gold from the company and kept the gold in the Manapuram gold. That is another case has been 420 has been registered.
So
only one case.
No, it is already you are in custody for 3 years and all, and 3 of the co-accused persons. One is Satyam.
Another is Saroj. And
just a minute, Satyam Purana ko?
Satyam Pradhan, my lord.
Satyam Pradhan.
That is BLFL number 9691 of 2022.
Satyam Pradhan ଆଉ ଗୋଟେ କିଏ?
Saroj Kumar Prushti and Lalit Kumar Soni.
Saroj Kumar Prushti. ଆଉ ଏରା ଲଳିତ କୁମାର ସୋନି ଆଦିରୁ ସୁପ୍ରିମ କୋର୍ଟରେ କିଏ ଯାଇଛନ୍ତି?
Lalit Soni.
Okay, but the council submits that you are not on the same footing. Status report, of course, indicate that out of 142, 8 witnesses have been examined. And you have got one criminal antecedent also.
That the on same transaction,
Ah.
not prior to. Prior to, no case has been registered again.
Now, here is a case where charge sheet has been submitted under which offences?
395 IPC.
Only offense 395 or
390.
other offences?
395 IPC. 395 read with 25-27 Arms Act.
If we come to that order which was passed in that earlier application, your earlier application is 1942 of 2021. There I have discussed the accusation against each of the accused, and so far as you are concerned, that is mentioned Ranjan Kumar Behera. The witnesses Shamsundar Ghosh, Asit Kumar Sahu, Soumya Sinha identified their placed gold in the company which were recovered from the possession of the petition. The statements of the independent witnesses sworn so, who are priests of the temple, revealed regarding conspiracy made by the present petitioner along with others prior to the occurrence. So, prior to the commission of offense, the petitioner, then Harmon Das, Lala, Amrit Sagar Roy, Rajkishore Sahu, along with some of the friends of Lala Amrit Sagar Roy,
They are
congregated together at Vaideshwar temple at Chaudhar, hashed out a criminal conspiracy to commit dacoity in the company to help the accused Lala Amrit Sagar Rai and others in order to save them from audit. The congregation of the petitioner with others at Chaudhar prior to the occurrence also fortified from the statement of the temple priests and called detailed reports. It also revealed during investigation that an amount of rupees 4,96,604 was transferred to the account of the petitioner by the accused. So, one thing is conspiracy. Second thing is recovery of those 2 kg and odd gold. Third is the transfer of 4 lakh and odd from the account of that accused Lala Amrit Sagar Rai. These are the materials. It's not that only co-accused statement as you said. And that is the reason why Mr. Tripathi says that your case is not similarly situated like that.
My prior before your lordship, as per allegation, everything has been recovered, my lord. And petitioner inside custody more than 3 years. And prior to this occurrence, no criminal antecedent.
It's a sensational case of dacoity in the broad daylight in
They are the employee. They made a plan.
in the
ଦେଇକିରି ଆମେ ସେଠି
midst
ମହାପ୍ରଭୁ
of
ବନ୍ଧା ରଖିବା।
Katak city, this crime was committed. It was that entire thing was CCTV footage also shows that how the dacoits after committing the crime fled away from that bank, and
ଡକାୟତି in the sense
3 years is not a
super addition କରିକି ସବୁ
actual.
ଡକାୟତ କରିଛନ୍ତି, my lord, but it is a case of, my lord,
Or the
fraud.
learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 25/11/2020. And out of 142 charge sheet witnesses, only 8 witnesses have been examined till date, which would be evident from the status report furnished by the learned trial court. The learned counsel further submits that charge sheet has been submitted against the petitioner under section 395 of the Indian Penal Code and 25 and 27 of the Arms Act. And 3 of the co-accused persons, namely Satyam Pradhan, Saroj Kumar Prushti, and Lalit Kumar Soni, have been released on bail in the meantime. And the case against and petitioner was arrested basing on the confessional statement of co-accused before police, and therefore the bail application of the petitioner may be favorably reconsidered, particularly in view of the delayed disposal of the trial. The learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that the petitioner is not similarly situated like the three co-accused persons who have been enlarged on bail. He further submits that the priest of Vaideshwar temple at Chaudhar has stated how the petitioner, along with the co-accused persons, has out a conspiracy to commit dacoity in the company to help Lala Amrit Sagar Roy and others in order to save them from the audit. And at the instance of the petitioner, 2 kg 12 grams of gold was recovered, which belonged to the company along with other articles. And an amount of rupees 4,96,604 was transferred to the account of the petitioner by accused Lala Amrit Sagar Roy. The learned counsel for the state submits that since number of material witnesses are yet to be examined, at this stage, if the petitioner is enlarged on bail, there is every possibility of tampering with the evidence, and therefore the bail application should be rejected. Considering the submission made by the learned counsel for the respective parties, the nature of accusation against the petitioner, the evidence adduced so far in the trial court, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody for more than 3 years, I am inclined to release him on interim bail for a period of 3 months. While on interim bail, the petitioner shall appear before the learned trial court on each date when the case would be posted for trial, and he shall not indulge in any criminal activity, shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail. Yes.
Go blade.
Item 29.
Okay. Okay, your lordship. Lordship, in this case, sub-item number 120, that is wrongly, my lord, in this case, that is the sub-item number 30, my lord, 14,446. 30 ର sub-item, ସେଟା 5120 ଟା.
It's all right. So you first argue this 1,444,5 of 2023.
Yes, my lord.
You
I'll
have
take
received the
instruction.
case.
No, but the first time it has come.
First time, Mr.
Yes.
All right, learned counsel for the state.
ସେଇଟା case, sir.
No, first time ନୁହେଁ, ଆଗରୁ ଆସିଥିଲା ଗୋଟେ।
My lord, ସେହି ଲାଲା ଅମୃତସାଗର case, this is ସେହି IAFL 395 case, my lord.
I will take instruction about that involvement. Yes.
The learned counsel for the state seeks some time to obtain instruction. এটা প্রথমটার লিখিবে, ହେଲା? Put up this matter on such and such date. আচ্ছা, 3 জন আজ লিখি দেবে, 3 of the co-accused persons have been released on bail. Shall verify the claim of parity. এই যে নাটা দিয়া হলানি, সত্যম প্রধান সেই কেসটা তো? সঞ্জয় সরোজ পুষ্টি ଆଉ
ললিত সোনি।
আচ্ছা, বাকি
Saroj Kumar Prishti.
ହଁ ଲେଖିଦେଇଛି।
My lord, another accused also, when Prakash Kumar Sahu also released on bail in this case.
এইটা কোন সেই কেস নয় কি যেটা পূর্বটা
Yes, yes, yes.
সেম কেস তো
Pro- oh.
প্রকাশ কুমার সাহুଙ୍କର ବିଲ୍ ଆପଣ ଫାଇଲ
Malord, ସେଟା sub item 30 ରେ Malord, ସେଟା।
ଆଚ୍ଛା ଏଇଟାର ସେକେଣ୍ଡଟା ସେଇଟା
ସେଟା
ସେକେଣ୍ଡ
ଏକା ଏକା
ଆଚ୍ଛା ସେକେଣ୍ଡଟାରେ କରିଦିଅନ୍ତୁ
ଏଇଟା ମଙ୍ଗଳବାର
14446 of 2023 list this matter along with PLA PL number 5120 of 23
Malord 51 ରେ already ମଗା ହେଇଥିଲା ଯୋଉ
ଷ୍ଟାଟସ ରିପୋର୍ଟ ମଗୁ
status
status
report।
report ଆସିଛି ସେ ଯୋଉ ଇଏ ପ୍ୟାରିଟି କରିକା ଦେଖିବା ପାଇଁ ସେ କରିନାହାନ୍ତି ଭେରିଫାଇ
ସେଥିରେ
ଆସିବ ସୋ ଏଇଟା ତା ସାଙ୍ଗରେ ଆସିବ ବାକି ଅର୍ଡରଟା ସେମ୍ କରିଦେବେ ତା ଦେହରେ କି ଏଇ ଯୋଉ କେସ ରେ କିଏ କୋ ଆକ୍ୟୁଜ ରିଲିଜ ହେଇଛନ୍ତି
Malord ଲଳିତ କୁମାର ସୋନି, ସରୋଜ କୁମାର ପୃଷ୍ଟି,
ସତ୍ୟମ
ସତ୍ୟମ, yes, Malord।
ସେମ୍ ସେମ୍ ଠିକ ଅଛି ସେ କପି ଗୁଡା ସବୁ ଆପଣଙ୍କ ପାଖରେ ଆଭେଲେବଲ ଅଛି ତ କାରଣ ଏଇଟା ସେକେଣ୍ଡ ଏଇଟା
Annex
ମଙ୍ଗଳବାର
3
କେସ ର
ଦେଖନ୍ତୁ।
ମଙ୍ଗଳବାର ପିଏସ୍ କେସ ର ସେଇ ତିନିଟା ଆକ୍ୟୁଜ ରିଲିଜ ହେଇଛନ୍ତି ଆଉ ଉପରଟା ହଉଛି 14445 ଟା କୋଉ ଥାନାର
14445 ଟା Malord ଲାଲବାଗ।
ଲାଲବାଗ ତାହେଲେ ଏଇ ଦିଟା ହେଲା ମଙ୍ଗଳାବାଗ ଆଉ ଏଇଟା ହଉଛି ଲାଲବାଗ
Malord, out of 15 charge sheet witness, 12 have already been examined।
ଏଇଟାରେ ଷ୍ଟାଟସ ରିପୋର୍ଟ ପୁରା ଆସିଛି ଅଛି
Malord
କୋଉଥିରେ ମଗା ହେଇଥିଲା
510 Malord।
51 ହଁ ଷ୍ଟାଟସ ରିପୋର୍ଟଟା ଦେଖି 15 14 ରୁ 15 ଟାରୁ 12ଟା ହେଇଗଲା ଠିକ ଅଛି yes next ତ next week ଆସିବ ଦିଟା
Item 31.
31 Mr. Panda
That's please your lordship on behalf of Mr. Panda
yeah
and every permitted. Here the petitioner is in custody since 21/11/2023. The offence is at annexure 1 page 6. Your lordship may see
now you have received the case diary
No, look, this is another.
ସେଇ ଜିନିଷଟା ତ ଆପଣ ସବମିଶନ କରିଥିଲେ ଗତ ଥର
the co-accused has been granted bail on similar footing.
no let him verify first the
PLFL 109594.
so which connected case record you said on 5-1 also same thing that the case diary is available in a connected case record
ସେ
today also you are
କହିଲେ ବୋଲି କହିଦେଲି ତାପରେ ସେ କେସରେ ଦେଖିଲା ବେଳକୁ ସେଥିରେ ନାହିଁ ବର୍ତ୍ତମାନ
ସେ
ଆଉ ଗୋଟେ
କହିଲେନି ସେ କହୁନାହାନ୍ତି ପୁଣି ଆଜି କହୁଛନ୍ତି କେସ୍ ଡାଏରୀ ଅଛି ବୋଲି
ନାଇଁ ଆଉ ଗୋଟେ ଦଉଛନ୍ତି ସେଇଥିରେ ଅଛି ବେଲ୍ ହେଇଥିଲା
ମୁଁ କହିବା କଥା ଭେରିଫାଇ କରିଦିଅନ୍ତୁ ନହେଲେ ମୁଁ କହିବି ଯଦି ଅଛି ତାହେଲେ ଅଫିସରୁ ଭେରିଫାଇ କରିଦିଅନ୍ତୁ ଅଛି ବୋଲି ନହେଲେ ନାହିଁ ଯଦି ପଳେଇଛି ତାହେଲେ ମଗେଇବେ ଥାନାରୁ ଏଇଟା ଲଞ୍ଚ ପରେ ଟେକ୍ ଅପ୍ କରୁଛି ତା ଭିତରେ ବୁଝି ଦିଅନ୍ତୁ ସେଇ ଯୋଉ ନମ୍ବରଟା ଦଉଛନ୍ତି ତା ଦେହରେ ଅଛି କି ନାହିଁ ହେଲା ଅଲରାଇଟ୍ ଏଇଟା ଆଫ୍ଟର ଲଞ୍ଚ ରେ
Item 32.
May I please run on last status report can call was called for status report of the trial.
Status report has come. Out of 27 charge sheet witnesses, 3 witnesses have been examined. So, petitioner was released on interim bail on 4 occasions, and he has surrendered at right time. That is the last time କେବେ ଯାଇଥିଲେ interim bail
21/7 21/7/2023
Yes, Mr. Tripathi heard the learned counsel for the petitioner and counsel for the state. Here is the status report dated 12/1/2024 of the London trial court, from which it reveals that out of 27 charge sheet witnesses, 3 witnesses have been examined so far, and the petitioner was released on interim bail on 4 occasions, and is surrendered at right time after availing the interim bail period. Considering the submission made by the learned counsel for the respective parties, the status report furnished by the learned trial court, the conduct of the petitioner in complying with the earlier orders of interim bail, I am inclined to release him on interim bail for 3 months. Disposed of. Yes.
Item 33.
My lord, Lordship, I am through virtual mode.
Yeah.
My lord, I am through virtual mode, Lordship. My lord, on the last date of hearing, Lordship, I directed the police of Malkangiri to verify that the police has not verified yet. Secondly, Lordship has sought for the report from the London trial court. So the cause list is showing that has not been filed. And one very pertinent question was raised by Lordship to my associate, Ms. Pandey, that what was the date of framing of charge? Lordship, I have got the instruction. It was framed in the month of January only. And Lordship, while disposing the first bail application in the month of July, I directed if the trial is not finished within the 6 months, then you can file the bail application. So I think we have filed the bail application on proper trial, Lordship.
First thing, status report was called for, was directed so and so. Sure. While submitting the status report asla ki? Okay, status report indicates that out of 17 charge sheet witnesses, 1 witness has been examined. All right. Then next thing is that
date of framing of charge.
Or it indicates about the
charge framing date.
Okay. Another thing is that yes, the petitioner is a man from Raebareli, UP, and the learning council for the state to verify. Yes.
A letter has been sent to instruction.
Address has not been verified yet.
SP Malkangiri is to take necessary steps.
Yes,
and whether communication has been made with the SP of Raebareli.
Yes, Miller.
What is that letter dated?
9/1/24.
9/1/24. Okay, Mr. Manohar, you do one thing. That is to be verified.
Lordship.
What is the names, address of the 2 local sureties in the meantime, so that
Lordship, I'm taking the liberty to furnish the document.
The learning council for the as per the order dated 5/1/2024, the learning trial court has furnished the status report, from which it appears that charge was framed against the petitioner on 15/1/2022. And out of 17 charge sheet witnesses, 1 witness has been examined by the prosecution. The status report is taken on record. Learning counsel for the state submitted as per order dated 5/1/2024. Superintendent of Police Malkangiri has made necessary communication with Superintendent of Police Raebareli, Uttar Pradesh, for address verification, but the instruction is still awaited, and he seeks some time to obtain instruction in that respect. Stop. Let the learned counsel for the petitioner furnish the names, address, and documents of 2 local sureties who are interested to take the petitioner on bail to the learned counsel for the state. On receipt of the same, the learned counsel for the state shall verify about the genuineness of the bailers, so also the authenticity of the documents put up this matter, the week commencing from such and such date. Gote saptah diyo. A free copy of the order be handed over to
I'm obliged, Lord.
For the state. Yes.
I'm obliged, Lordship.
Item 34.
May plus.
Yes, Mr. Dwivedi.
It is the fourth bail application. Earlier, my lord, in the present case,
Crown submitted that he has received the case diary. Petitioner submit that some of the witnesses have been examined in the trial court and supply the certified copy of the Delegi.
One thing I am submitting here, my lord, out of 3 eyewitnesses, 2 witnesses have been examined. Roti Godnak is to be examined. My lord, the case is posted to 31st of this month. Lordship may direct to produce.
Okay. The learned counsel for the petitioner, while filing the deposition copy of some of the witnesses, and furnishing 4
1 to 4
PWs 1 to 4 like them, and supplying the same to the learned counsel for the state, submitted that one of the eyewitness, namely
Roti Godnak,
is yet to be examined and his date of examination is
no,
posted.
not date of examination. So someone ta taku issue korunanti because in the CW list he is last matter.
Acha. But no summons have been issued to the said eyewitness. In view of such submission, let the inspector in charge of Kaniha police station appear before the learned trial court, that is learned additional session judge Talcher, in city bracketary S number 38 of 2017 on or before 27th of January 2024, receive summons in respect of the aforesaid eyewitness and ensure his attendance on the date fixed. Put up this matter in the week commencing from 5th of February 2024. If the said witness is examined, learned counsel for the petitioner shall produce the certified copy of his deposition, giving copy thereof to the learned counsel for the state. Free copy of the order be handed over to the learned counsel for the state, which will be forwarded to the concerned IAC for compliance.
This petitioner having 8 criminal antecedents.
Acha, the learned counsel for the state submitted that the petitioner has got 8 criminal antecedents. Let the learned counsel for the petitioner obtain instruction in respect of such antecedent and file a comprehensive affidavit relating to the status of those cases. Case number 1. Yes. Yeah.
Item 35.
I believe, Lord. My lord, in this case, my lord, this is
Item 36.
36. May I please, your lordship? Here the appellant is for bail. Before your lordship, last occasion your lordship directed to obtain the custody certificate.
And
Yes, my lord. 6 years, 6 months, 29 days.
Total
10 years.
10 years. Diyantu se custody certificate ajan. Loko gudi karan.
Koraput. My client is from Koraput.
Acha. Lakshmindar Adari hochi 6 years.
6 years, 6 months.
Like out of 10. Aguri jaithile?
Jaithile.
Out of 10 years, he has already undergone 6
Interim
years.
bail.
Earlier, he was granted interim bail, surrender at right time, 3 months bail granted. है ना? It's a criminal appeal. He will file the surrender certificate. Yes, Mr. Panda, what is your case?
More time, but in fact, since outsider, 1 CRLA 616
ନାଇଁ 616 ଟା ଗୋଟେ ଗୋଟେ କୁହନ୍ତୁ
ସେଇଟାରେ ମିଲର ଆଡ୍ରେସ ଭେରିଫିକେସନ ହେଇଛି ଲୋକାଲ ସିକ୍ୟୁରିଟି ପାଇଁ
ଅର୍ଡର ହେଇଥିଲା
ନା ହେଇ ନଥିଲା
ଇଏ you have got the custody certificate of the second one case of
till the date of arrest ମିଲର ରହିଛନ୍ତି ମୋଟେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଇ
yes case of the report
7 years 3 months 27 days
ଆଉ address verification ହେଇଯାଇଛି କଣ ବାହାର ଲୋକଟା କହୁଛନ୍ତି ଛତିଶଗଡ଼ର
yes
not correct address is
ଏଇ ଦିଅନ୍ତୁ କଣ ଦେଇଦି କରେକ୍ଟ ଆଡ୍ରେସ ନୁହେଁ କୁଆଡେ କଣ ଆଡ୍ରେସ ଆଣି ଦେଇ ଦେଉଛନ୍ତି କୁଆଡେ ଖସି ପଳେଇବ ଦିଅନ୍ତୁ ସେ ରିପୋର୍ଟଟା ଦିଅନ୍ତୁ the Land and Council for the state has obtained instruction এটা লিখিবে CRLA number 616 2022 from नहीं first like the Land Council for the state has obtained instruction from the Senior Superintendent Circle Jail Koraput to the effect that the petitioner has already undergone 7 years and 3 months of sentence. The report out dated 21/12/2020. Case of Chandra Ture. However, he has further taken instruction and produced a letter of the Superintendent of Police Koraput, wherein it is mentioned that the address given by the petitioner in the cause title is not correct. Both the reports are taken on record. Land Council for the appellant submits that he may be given some time to obtain instruction in the matter and to furnish correct address of the appellant. Put of this matter out a date there. Second,
pardon my lord.
This is
the first one, Lakshman Adari plant case. Your lordship granted interim bail.
Yes, in 3 months.
second ମିଲର କିଛି order
6 years
କୋଉଟା କହିଲେ
third ଟା ମିଲର
just
619 ରେ ଏଥିରେ address verification ପାଇଁ order ହେଇନଥିଲା order ହେଇ
এটা হচ্ছে furnish correct address and এটা করবি আমি দেবো first interim bail for 3 months second ଟା হচ্ছে fresh address ହେଲା ଆଉ ଇଏଟା ଦେଲେ custody certificate ଟା produce କଲେ ହେଲା third ଟାରେ କରିବେ ଯେ address ଏଟା ଇଏ ବି ବାହାର ଲୋକ କୋଉଠି ଆଣ
yes ଇଏ ବି verification ପାଇଁ order ହେଇନି ହବ ମିଲର
ଆଚ୍ଛା ଲେଖି ଦିଅନ୍ତୁ ଏଇଟାରେ ନେଇ ଆସିଛନ୍ତି ଆପଣ custody certificate ଟା
ସେମ୍ 36 ପ୍ଲସ୍ ଟା କୋଉଟା ଗଲା 619 ଟା ସେମ୍ ଗୋଟେ ଡେଟ୍ ଶୀତଲ ସିଂ
ତାର ଆସିଯାଇଛି କଷ୍ଟଡି
କେତେ ଦେଇଛନ୍ତି ସେଟା CRLA number 619 of 2022
ତାରୁ ଏକା
the Land and Council for the state has produced the custody certificate of the appellant which indicates that he has undergone so as per the court dated so furnished by so the address verification
order ହେଇନି
however it seems that the appellant is a man from state of Chhattisgarh. Let the Land and Council for the address verification by usual order for the SP Koraput make you necessary communication with the SP of Balud district in the state of Chhattisgarh. Yes, next.
Lakshman Adari case re तार stay of fine your lords में that is
अच्छा stay जो IN number 1 से जो प्रथम item टारे 1607 of 2022 रे stay of realization of fine करी आईए टाକୁ डिस्पोज ऑफ कर दिया हाँ अच्छा ये जो आउ गुड़ाकर देखंतु सेकेंड टारे मध्य आईए नंबर 1181 ऑफ 2022 सेटारे स्टे कर देबे स्टे ऑफ फाइन थर्ड टारे मध्य आईए नंबर 1188 ऑफ 2022 स्टे ऑफ फाइन कर देबे है ना से आईए गुड़ा डिस्पोज ऑफ कर देबे हाँ ओके एड्रेस वेरिफिकेशन हबो custody certificate formation. Yes.
Item 37.
That last token last direct for the custody certificate called formula.
Item 41.
Your Lordship, on earlier occasion, custodial certificates to be produced by the London Government Council.
I've obtained it, Your Lordship.
Oh, what is the total period?
That's approximately 4 years and 9 months, Your Lordship. I calculated.
And what is the sentence?
Sentence is 10 years, Your Lordship.
No, I am custodian is 6 years, 4 months, and 22 days. Custodian is 6 years, 4 months, 22 days. But I am interim order was there for 3 months. Only by this honorable court. Custody is again 30/8/2017.
That is mentioned here.
Yes. But from 16/12/2019 till 1/7/2021, he was not in custody, as per the report.
You are released on bail during trial.
I was not bail. Only by this honorable
court.
Only this honorable court released on bail for 3 months.
– 16/12/2019. No. You are released on interim bail from 16/12/2019. That too for a period of 6 weeks, and you surrender on 27/1/2020. That is, then you are in custody. Begin up to 9/4/2021. One 7/2021. Bail. This period has not been taken into account. You are also in custody from 27/1/2020 to 9/4/2021. That letter which is you produce,
Lordship.
there under trial period lekha hoichi na jo 16/12/2019 on that day he was released from custody.
My lord.
That was a period for 6 weeks and he surrendered on 27/1/2020. Okay, then he was released again from custody on 9/4/2021 and then he surrendered on 1/7/20. तापरठू जोड़ा ठीक अछि एइटा आपनकर केते मास हेइतला हिसाब करथिले 4 years
4 years and 9 months approximately.
9 months ता देरे एइटा को जदी मिसा जीवो then February 1 to 2 months and 10 days holo consider about 5 years as jauchi. And this report is dated 10/12/2023.
Lordship.
So more than 5 years. What is the sentence imposed?
10 years, my lord.
Okay. Page relevant.
Page 32, my lord. Page 32, para 25, starting from last 2 line. Thus, the convict Kanha alias S.K.SAHOO is sentenced to undergo rigorous imprisonment for 5 years for offense under section 450 of IPC and pay a fine of 10,000.
Right. IA number so and so. This is an application for bail. The Lieutenant Counsel for the state has produced the custody certificate dated 10/12/2023 from Superintendent Subjail Titlagarh. And on verification of the trial court record, it is found that though the petitioner was in judicial custody since 27/1/2020 to 9/4/2021, but the same has not been shown in the custody certificate. Land Counsel for the state submitted that if the said period is taken into account, then the petitioner has already remained in custody for more than 5 years. Considering the submission made by the Land Counsel for the respective party, aguru meritary reject it lagi.
No, my lord.
Bail application
On 9/5/23, your lordship.
9/5
2023.
That was he was granted interim
Bail for 3 months, my lord.
3 months. That the petitioner has already undergone half of the substantive sentence imposed by the London Trial Court, and the conduct of the petitioner in complying with the earlier order of interim bail granted on 9/5/2023 in IA number 375 of 2023, and absence of any chance of early hearing of the appeal in the near future, I am inclined to release the petitioner on bail subject to condition that the petitioner shall not try to come in contact with the victim or not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail allowed.
Item 42.
May I please, my lord, last occasion there was a direction to bring instruction regarding the illness of the father of the petitioner. It is for hearing.
It's an interim bail application.
My lord.
So what instruction you have received, Mr. Mishra?
Lordship, I've given a copy to the court master, my lord.
Yeah.
He is able to maintain his daily routine.
The condition is good and capable of maintaining daily routine work, moving freely, and the documents are genuine, and the younger brother of the one. So yes, so everything is okay.
My lord.
IA number so and so. This is an application for interim bail on the ground of ailment of the father of the petitioner. The Land Counsel for the state has produced the written instruction received from IIC Padua Police Station dated 22/1/2024, from which it appears that the health condition of the father of the petitioner is good and is capable to maintain his daily routine work and is moving freely to different places for business purpose to maintain his livelihood. In view of such report furnished, I am not inclined to release the petitioner on interim bail. Accordingly, the IA is rejected. Yes, next.
Item 43.
May please, Your Lordship.
All right, learning it C number two. All right, learning counsel for the state submitted that since the inspector in charge of Raibonia police station received the intimation from the AG office on 11/1/2024.
19/1
हाँ
ଓ 19/1 ରେ 19 ରେ ପାଇଛି
नहीं डेट थिला
11/1
डेट थिला 11/1/2024 रे
लेट रे पाइଛି
लेट अच्छा कुछ छाड़ जन couldn't get in time he couldn't get the intimation from the AG office in time could not comply the order dated 5/1/2024. The land counsel for the petitioner submitted that the next date of trial is
7th February 2000
7th February 2024. In view of the submission, से जो ऑपरेटिव पार्ट रे अछि जो लेट दी आईआईसी रायबनिया पुलिस स्टेशन अपियर सेटा सब रहिबो खाली लिखि देबे ऑन और बिफोर उटा दे दियंतु ऑन और बिफोर 29th पर्यंत 29th चले हाँ 29 January 2024 and receive summons and ensure that बाकी सब certified copy to be produced 7 तारीख रे जेहेतु अछि आपण we commencing from bar रे रखंतु हला will produce the certified copy of the deposition of the victim giving copy to the land counsel for the state. Yes, published and free copy of the order then.
Item 31.
Made, please, my lords.
एटा कोन पे रहितला after
My
lunch?
lords, the CD was in a connected matter. Where your lordship.
Yes, we do.
Please, your lordship. My lords. My lords, the FIR was lodged against two persons who were apprehended at the spot under section 274, 275, 120B. Subsequently, a charge sheet has already
What
been...
they were carrying?
Lords,
Cough syrup.
Cough syrup.
Yes, my lords. It is based...
You were not there at the spot.
No, my lords. I was not apprehended at the spot. Subsequently, the two
Your
persons
name
disclosed.
was disclosed by the two co-accused persons.
My lords.
So, apart from that, what other materials are there? Co-accused statement is there.
Yes, my lords.
And anything recovered when you are arrested?
No, my lords. As far as the charge sheet is concerned, my lord,
Yeah.
the charge sheet I have annexed. Your lordship may kindly have a glance. Brief facts. That is as page 32. Relevant portion is on page 33, wherein they say that, my lords, I'll draw my lord's attention to 11 lines from the top, my lords.
On being asked, two persons disclosed.
Again.
They also disclosed name of so and so. No, when you were taken into custody.
My lords, I was taken into custody on 21/11/2023.
21/11/2023. So when you were arrested, any incriminating articles were seized, like cough syrup or anything?
No, my lords. My lords, because...
Mr.
No, my lord.
Nothing. Any CA?
No, CA.
Are the learned counsel for the petitioner, Mr. Sudipto Panda?
One CA, my lord.
What
One
is
CA, that is contravened PS case number 57 of 18 under 52A of Odisha Excise Act.
ସେଟା ୟାର ଥିଲା co-accused ର co-accused
ଏଇଟା CD ଟା
ୟାର
Considering the submission made by the learned counsel for the petitioner, Mr. Sudipto Panda, that the petitioner was not apprehended at the spot, but his implication in the case is based on confessional statement of co-accused before police, and he was taken into judicial custody on 21/11/2023, and no incriminating articles has been seized from his possession. And after hearing the learned counsel for the state, was not disputed that the only material available against the petitioner is the confessional statement of co-accused before police. I'm inclined to release the petitioner on bail and out.
Ungrateful, my lords.
Item 51.
51, Mr. Das.
May I please,
Yes.
may I please, Lordship, my lord. My lord, operative portion of the sentence. May kindly have glanced to page. Sorry. My lord, page running page 34, internal page 24, my lord.
20 years.
Yes, my lord, 20 years.
You are giving the deposition copies.
I have already given, my lord. In
So-
my favor, my lord, two materials in my favor actually. Otherwise, in the examination, it has come out from the mouth of informant as well as the victim that there was prior dispute between the family. And medical examination is absolutely silent about the injury and other recent sexual intercourse between the parties. Even the doctor who has been examined the accused as well as the doctor who examined the victim, it came out, transfer also. And one more thing here, my lord, the witness, the father, who's the informant in the case, he was sleeping outside the room where the incident occurred at veranda, and the accused was inside the room for 2 to 3 hours, but he could not know about the things. That is
Victim is PW?
Informant PW1 mail.
Victim.
PW2 mail. And during trial, he was inside the custody. He was inside the custody since July 2021. That is exact date is, my lord, 9 July 2021.
So she was about 13 to 14 years perhaps in time of occurrence. Because when she deposed, she stated her age to be 15 years.
Yes, but that comes out because the school certificate also speaks that also.
He wants to enter into the bedroom of him. Open the door, so on, so come. My sleeping in there. Each दिन want. March masero. Yes, next.
Yes, ma'am. These cases are live.
Serialization of fine allow कर दिया.
Oblige, ma'am.
IN number so and so well March 2024. Yes, next.
Oblige.
Item 52.
May I please your lordship? In this case, the appeal has been admitted on 30th October. As per the direction of the Honorable Court, I have filed IA.
Lordship, our office noting is that we have not yet received a copy of the CRLA, Lordship.
Appeal memo you have not received.
Submitted.
So,
sir,
Mr. Pradhan, the London State
Yes,
Council is having no brief with him. You have not supplied the appeal memo.
Yes, you have supplied.
Mr. Pradhan sworn, so let the matter immediately after. No, on that day also, when the matter was admitted on 30/10/2023, on that
Yes,
day
sir.
there was a direction to supply the London State Council a copy of the appeal memo along with the impugned judgment. So when you supplied that?
It has been supplied, but if for any reason she has not received, I will supply again.
Okay. The London Council for the appellant submits that will supply the copy of the appeal memo. Mr. Asian Pradhan, London Council for the appellant appearing through virtual High Court, Rourkela, submit that he will supply copy of the appeal memo along with the impugned judgment and copies of the interim application on the Land Council for the state. During course of this week, Kale chalibo? All right, during course of this week. put up this matter in the week commencing from 5th
My lord, NBW is pending against me. My lord, NBW is pending against me. At any time, I may be apprehended. I am a senior citizen.
No. What is this? You are.
I may be allowed, and I will serve copies of all the documents shortly
No,
in this week itself.
You are sentenced to undergo 3 years under section
3 years only 3 years.
So,
Under section 325 IPC.
granted you bail also, interim bail to obtain it from the. So, it's a formality to be right. So you supplied and during course of this week, I'll take up next week, 29th version. Since it is stated that non-bailable warrant of arrest has been issued against the petitioner because he is unable to get the bail order from this court, as he was granted interim bail by the London trial court after conviction. Till next.
I will be disposed. Thereafter also I can supply copies. Because NBW is pending, I am running a risk of getting arrested at any moment.
Give the till next date, the petitioner shall not be arrested in pursuance of the non-bailable warrant of arrest issued by the London trial court.
Obliged.
Yes, next.
Item 53.
May I please?
86.
Hmm.
Sentence will to undergo RI of 7 years and to pay fine 5,000. In default, undergo RI 6 months and under section 304 part 2, 34 of IPC, my lord. And the can be further sentence to the undergo RI of 1 year.
Have you supplied the deposition copies?
Yes,
My
Lord.
So it is 7 year sentence.
My lord.
304 part 2.
Part 2.
You are on bail during trial.
My lord.
Eyewitnesses are there.
My lord, direct eyewitness 1, PW7.
And who is the doctor? PM?
My lord, PW10.
PW9 is the doctor, your lordship.
9.
My lord.
9.
And PW6 is the doctor who has conducted the post-mortem examination. And PW9 is the doctor who has examined the injured, PW7.
No, ये PM report
PW6, my lord.
6 such.
Right, 6.
And what is the weapon of offense? Split bamboo.
Bamboo.
Law option. It is kejon appellant अछन.
My lord, 7 accused.
No, in this criminal appeal.
My lord.
All the 7 are filed.
No, lordship, only one. Sanatan Das.
Sanatan Das, other appellants also another case.
ଆଜି ଅଛି list ରେ?
ନାଇଁ ଆଜି
ନାଇଁ ତ କେହି ଗଲେଣି ବେଲ୍ ରେ?
No, my
ସେ ଆଇ ୱିଟନେସ୍ ର ଦେଖିଲେ ଆ ନାଁରେ କଣ କହୁଛି ମିଷ୍ଟର ମିଶ୍ର?
PW7
PW7 ରେ ଦେଖିଲେ ସେ ଆ ନାଁ ହଉଛି ସନାତନ ଦାସ। ଜନି ବାବୁ ନବ ସେଠି ସ୍କୋଲ୍ଡେଡ୍ ଅଛି। ଜଗା ଜନି assaulted. Name of the deceased କଣ କହିଲେ?
My lord, ଜଗା।
ଜଗା।
ହିମାଂଶୁ ରଣା alias ଜଗା।
ଫାର୍ଷ୍ଟ ହେଲା ବାବୁ ନବ dealt so and so to him. ଆଚ୍ଛା।
The position is that one Chabi Palei, he assaulted by means of the bamboo split, your lordship. And this present accused, he dealt fist and kick blows to the. That is at lordship deposition of PW7.
Kalu and Tonna dealt fist and kick blows.
line move.
Lords, that is the 6th line from the top.
Satyajit Naik, Kalu and Tonna. Yana
Tonna.
Sanatan Das alias
Tonna. Dealt fist and kick blows. Achha. Or the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submit that the petitioner was on bail during trial and has never misutilized his liberty. He further submit that the sole eyewitness to the occurrence of PW7 was stated that co-accused Chabi Palei assaulted the deceased Himanshu Rana alias Jaga by bamboo split bracket like to Botta and the petitioner along with 2 co-accused namely Satyajit Naik and Kalu dealt fist and kick blows to him. Kick blows to him for which he sustained bleeding injury. Chabi কথাটা কোডি কোয়ালা Chabiটা assaulted me কହୁଛି ପରା Mr.
Lordship.
ନାଇଁ deceased କୁ Chabi assault କଲା ତ କିଛି ନାହିଁ ଆଉ ଥରେ ଉପରୁ ଆସନ୍ତୁ I along with so and so went to the spot gala came in a motorcycle. Okay. Johnny so and so assaulted
Johnny Paisetti assaulted Jaga by bamboo.
ସେଟା କାଟି ଦିଅ ଲାଗି ଦିଅ PW7 stated that Johnny, Babu and co-accused persons କରିଦିଅନ୍ତୁ Johnny, Babu and Nobosetti scolded the deceased and Johnny assaulted the deceased by means of split wood. split bamboo, bracket re bata. And Babu and Naba dealt slaps and kick blows to him. And the petitioner has been implicated in the assault of PW 7, and it is stated that he gave kick and fist blows to PW 7. The London Council further submit that since the sole eyewitness to the occurrence has not attributed any specific overt act of assault to the deceased against the petitioner, and there is no likelihood of the appeal being taken up for hearing in the near future, and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Learned counsel for the state placed the evidence of the eyewitness PW7, so also the doctor bracket PW6 who conducted post-mortem examination. Considering the permission made by the London Council for the respective parties, nature of evidence adduced, the fact that the petitioner was on bail during trial and absence of any material that he misutilized his liberty in any manner, absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay realization of fine.
Item 55.
Yes, Mr. Das. For admission, further proceeding. What is the CRLA for? OPID matter?
Yes, ma'am.
Mr. Patro? Yeah. What is your prayer?
Petitioner, sir, has filed an application to discharge and the same has been rejected by the trial court for which he has come up before the Honorable Court.
Where is that rejection order?
That is number PS 200.
212.
204.
212.
204 to 216, madam.
The order dated 7/10/2023.
212. Acha.
Yes.
Okay. 239 so and so.
In my case, page number 204 to 216.
So, Mr. Das.
Yes, ma'am.
Oh, this petition was rejected on 7/10/23 and the case was posted to 11/10/23 for framing of charge.
Yes, ma'am.
So what happened on 11/10?
Till today, my lord, charge has not yet been
Yes,
framed.
Mr. Patro.
And the instruction. All the documents have not been supplied to the different accused persons. They have also filed an
copy.
They have also filed an application.
11/10/2023 ରୁ ଏପର୍ଯ୍ୟନ୍ତ ଅଛି କପି ସେ କହୁଛନ୍ତି ତା ଉପରେ ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ ଆପଣଙ୍କ ପାଖରେ କାଗଜ ନାହିଁ ମୁଁ କେମିତି ଜାଣିବି ଯେ ଚାର୍ଜ ହେଲାଣି କି ନାହିଁ
ହେଇନି your lordship may take our submission step.
No, call for a report.
କେବେ ଅଛି ତାରିଖ କେବେ ଅଛି ତଳ କୋର୍ଟରେ
31st of this month.
All right. It is stated by Mr. Devasnanda. The case is posted to 31/1/2024. While the impugned order dated 7/10/2023 indicates that the case was posted to 11/10/2023 for consideration of charge against the accused persons. Mr. Das submits that he has instruction that charge has not yet been framed. When a query was made to the London Council, Mr. Patro, London Special Counsel for the State of Orissa in OPID Act matter, about the status of the case, he submit that he has no instruction. In view of such, and since the London Council for the petitioner is not producing the certified copy of the order from 11/10/2023, let instruction be obtained from the London Trial Court by the registered judicial by Friday, whether the about the status of the case put of this matter on 29th of January 2024.
Can I criminal an application for adjournment to be filed?
ସେଇଥିପାଇଁ ରଖିଲି ପୁରା 29 ତାରିଖରେ ଆପଣଙ୍କର 31 ତାରିଖରେ ତାରିଖ ଅଛି ଆଉ 29/1/2024. Yes.
The connected matter similar.
With list this matter along with CRLN number 1219 of 20. Yes, next.
Item 56.
Supplied, yes.
That may be.
ଗୋଟେ ସପ୍ତାହ ପରେ ଆସିବ, yes.
Item 57.
May I please, Your Lordship? My Lord, kindly see the order dated 9/11/2023, my Lord. 9/11/2023. The petitioner was charged under Section 376 IPC, but conviction under Section 354 IPC for a period of 6 months, my Lord. The matter was admitted and the petitioner was on, appellant was on bail. At the time of hearing, nobody was appearing for the appellant. NBW issued by Your Lordships, and on 22/11/2023, petition was voluntarily, bailer was produced before the trial court, and petitioner since custody, my Lord.
ଶୁଣିଦବା ଆଉ କଣ ଆଉ ଭିତରେ ତ ଆସିଲାଣି ବୁଲିକିନା ଆସିଲା ବାହାରେ ଆଉ ପୁଣି ଖସିଗଲେ ତ ପୁଣି ଆଉ ଆପଣଙ୍କୁ ବର୍ତ୍ତମାନ ଏନଗେଜ କରିଦେଲା ଆର୍ଗୁମେଣ୍ଟ କରିଦିଅନ୍ତୁ ଏଟା 2001ର ଅପିଲଟା
ଗୋଟେ ସର୍ଟ ଡେଟ୍ ଦିଆଯାଉ ଖାଲି
ବେଲ ଫେଲ ନାହିଁ ପୁରା ହିୟରିଂ କରିଦିଅନ୍ତୁ
22ରୁ ରହିଲାଣି ଆଇ ଏମ୍ ରେଡି କରିଦେବି ଗୋଟେ କରିଦେବି ମାସରେ
2001 ମସିହାରେ ଆପିୟର କଲେନି ବୋଲି
ମୋ ପାୱାର ନଥିଲା ଅଦର୍ସ ଲୟର୍ସ ଆର୍ ନଟ୍ appearing on that day 9/11/2023
ପେପର ବୁକ୍ ପାଇଛନ୍ତି
ମୁଁ ସ୍କାନ କରି ଗୋଟେ ନେଇଛି
ରହିଯିବେନି ତ ହିୟରିଂ ଡେଟ୍ ଦିନ ପୁଣି
yes my lord I am ready
କୋଉ ଦିନ ରଖିବା ତାହେଲେ 31 ତାରିଖ ଦିନ ରଖୁଛି
this month
ହଁ
hello
ସିଙ୍ଗଲ ବେଞ୍ଚ ଅପିଲଟା ପ୍ରିପେୟାର ହଉ କେତେ ଦିନ ଲାଗିବ ଲେଖନ୍ତୁ IN ନମ୍ବର 1 ଶୋ Ms. Dipti Rakharonda, Law and Counsel for the submits that you will obtain the paper book from the registry and get ready to argue the appeal. And since the petitioner was on bail and due to non-appearance from the side of the appellant, taking into account that the appeal is of the year 2001, the bail order was recalled and a non-bailable warrant of arrest has been issued, by virtue of which the petitioner has been taken into judicial custody. He may be released on bail. Law and Counsel for the state has no serious objection, considering the submission fact that the appellant was on bail and the Law and Counsel petitioner is now ready to argue the matter. I am inclined to release the petitioner on bail. Satisfaction of the learned additional session judge both in ST case number 15 of 2000 bracket ST 80/99-DC put up this matter for hearing on 31st January 2021. Registry shall supply the paper book to Ms. Nanda. ଏମାନଙ୍କ ନାଁ ରହିବ ନା କାଟିଦେବି ସମସ୍ତ
ମୁଁ ତାଙ୍କୁ କାଲି ରାତିରେ ବି କଣ୍ଟାକ୍ଟ କରିଥିଲି I contacted them but nobody will respond ମୁଁ କହିଲି ଆଜି ପ୍ରେଜେଣ୍ଟ
ଆପଣଙ୍କ ନାଁଟା ରହିବ ଆଉ କାହା ନାଁ ରହିବ କୁହନ୍ତୁ
ଅନନ୍ୟା ମିଶ୍ର
ଆଉ କାହା ନାଁ
ଅନନ୍ୟା ମିଶ୍ର
Ananya Mishra except the name of Miss Dipti Rakhananda and Ananya Mishra. The names of other counsel shall not be reflected in the cause list henceforth. Yes.
Item 58.
Please, Your Lordship. Lordship, I file a interim application 3095 of 23, my lord, at flag C, for permission to prepare the paper book, my lord, and for fixation of early date hearing.
This is a
appeal of 2014, my lord.
Okay, Republic of India. Yes.
Your Lordship, I am appearing on behalf of Mr. Naik, Your Lordship.
So, any objection? He wants to prepare the paper book and file.
As Your Lordship may please, Your Lordship. No objection.
Number so and so. This is an application for early hearing. Law and Counsel for the petitioner submit that the appellant is ready and willing to prepare the paper book. In view of submission, let the required number of paper books be prepared by the Land Counsel for the appellant and filed. Whereafter this interim application shall be and the registry shall verify the same. If it is in order, the IS shall be placed for consideration. How much time you want?
Lordship, 4 weeks.
4 weeks time. Prepare the paper book within 4 weeks. Kar do, hai na? Yes.
Deeply obliged, my lord.
Much obliged, Your Lordship.
Item 59.
Mr. Devasnan Das.
My lord, pleasure. My lord, appellant challenge.
Okay, mic ku tikke tolgu ne asun. Come on.
Appellant challenged the appraisal judgment in this criminal appeal. During penning of the appeal, sole appellant died, leaving behind his wife, 2 sons, and 1 daughter. My lord, present petitioner wife of the appellant filed IN number 2509/2023 for grant of leave.
When the death took place?
Parampur.
Death took place. Date of death.
9th in Satara.
So you are supposed to file that application within 30 days. Yes. As per 394 subsection 2 proviso.
Yes.
So you filed this interim application in the year 2023. So that is why you have filed an application for condonation of delay. Yes, Mr. Das, what do you say?
Name of Mrs. Josnarani Tripathi may be edited and my name may kindly be reflected.
Or Mr. Sanjay Kumar Das, Land Counsel for the...
My lord, the Land Council should correct the cause title for in 2509.
2509.
Application under section 349. 349 is...
And see, 80 correction kar dijandi.
80
correction karnandi. Eti court record re correction neji affidavit purvu.
Yes.
ଆଉ
And once one IA was filed and it was withdrawn on 21/9/2023. Earlier, it has been mentioned in the application itself. Another IA was filed 1915/2023, 10/8 and it was withdrawn on 21/9/23.
এইটা থার্ড অ্যাপ্লিকেশন,
এটা second application.
Present inquiry into the matter so on. So
Let a small amount be deposited in the High Court bar.
ଆଗଟା କଣ
Welfare fund.
ସେ ଲୋକଟା ମରିଗଲାଣି, ତା ସ୍ତ୍ରୀ ଆସିଛି ପରେ ଆଉ ସେ
No copy of IA 1916 has been served on.
IA ନମ୍ବର
1916-23 no copy has been served.
ଦିଅନ୍ତୁ ତାଙ୍କୁ ସେ କପିଟା ଦେଇଦିଅନ୍ତୁ। IA number 2510/2023. This is an application for condonation of delay. After hearing the learned counsel, ଆପଣ ନାଁ କଣ?
S. Mahakumaar.
ପୁରା ନାଁଟା କୁହନ୍ତୁ, କାଗଜରେ ଟିପି so and so, and Mr. Sanjay Kumar Das, learned standing counsel for this one. I'm inclined to condone the delay in filing the IA number 2509 of 2023 for grant of leave to prefer the appeal. Accordingly, IA is allowed. Then IA 2509 of 2023. There is an application for grant of leave to continue the appeal. It is stated in the interim application that the sole appellant, Vijay Kumar Naik, died on 9/3/2017, and the present petitioner is the wife of the deceased appellant, and she is interested to continue the appeal as she was unable to get any family pension and other financial benefit of her husband on account of pendency of the appeal. Learned counsel for the state, standing counsel for the vigilance department has no serious objection. Accordingly, leave is granted to continue the appeal. The learned counsel for the appellant shall file press cost title, consolidated, not a press cost title for them, giving copy to the learned standing counsel for the vigilance department. IA number 1916 of 2023. There is an application for fixing early date of hearing. Mr. Sanjay Kumar Das, learned standing counsel for the vigilance department, submit that the copy of the interim application
Served in court.
Served in court. And this, you see, madam, this appeal can only be fixed for early hearing, provided that you prepare the paper book and file it, and the registry will verify, and if it is found to be in order, then can the order appropriate. Otherwise, it cannot be done. So take instruction whether your client is ready and willing to prepare the paper book or not.
Yes, madam.
Ready?
Yes.
All right. The learned counsel for the petitioner submit that the petitioner is ready and willing to prepare the paper book and file required number of paper and file the same. And for such purpose, he requires how much time?
February, any date.
Okay, 6 weeks time for the said purpose. After the learned counsel for the petitioner files the required number of paper books, same shall be verified by the registry, and if it is found to be in order, this IA shall be placed for consideration. You are to file that cost title, right?
Yes,
That cost title, this name is to be inserted, okay?
Today's free copies order में
Free
kindly
copy of the order be handed. अच्छा, लेकिन in place of the name of Mrs. Jyotsna Rani Tripathi, name of Mr. Sanjay Kumar Das, Standing Counsel, be reflected in the cause list also in the top of the brief. Free copy of the order be handed over to Mr. Das. Yes.
Obliged.
Item 60.
Please, my lord. My lord, here.
Wait. Press non-surrenders report of so and so. Accused petitioner appellant number 3 praying for engagement of so and so in place of.
Sir, I am appearing for appellant number 4, that is Sumana Sahani only.
You would have bail surrender karni na.
I think my friend is appearing for you.
Praying for an adjournment.
4 number ପାଇଁ ଆପଣ
Yes. Sumana Sahani. Kalia alias Sumana Sahani. Driver.
Who application ne?
No, this
CRL ଅଛି.
Sir.
Who CRL
544 of 2016.
What is your application, bail application number?
That is Madhyam Behra.
What is the IN number? You are appearing for appellant number 4.
Sir.
In CRL number 544 of 2016.
No. 648. Sir, 648. No, 648 of 2016.
He's appellate number 3 in CRL number 648 of 2016.
Yes, 648 of 2016.
Okay. So your bail application number is IN number 2405.
Sir, 2405. Sir, out of 10 years, he has already been in custody.
Business petition in Gola. In this regard, clearment from the file of claim without taking consent of the state to produce the custody certificate.
Not just I will pray for next week.
Okay.
I've already contacted.
Sir, 9 years, 6 months out of 10 years, sir.
Next week, the London Council for the IN number 2405 of 2023. This is an application for bail of appellant number 3. The London Council for the state seeks some further time to produce the custody certificate. Are you aware in which jail he is now?
Yes, we have sent it to Kandhamal jail.
Fulwani. Yes.
Put up this matter as a period the prisoner's petition for engagement of Mr. Niranjan Panda instead of Amulya Ratna Panda as his advocate. Mr. Panda has also filed Vnama for appellant number 3. The Wakalatnama is accepted. Mr. Panda shall now be the advocate for appellant number 3. तापर लिखिदेवे जो custody certificate बनेगा. Yes, put up this matter in the week commencing from 5th February 2024.
Item 61.
My lord, this matter, the petition is also languishing in jail custody that more than 8 years, 6 months.
Order of the Honorable Supreme Court regarding expeditious hearing at flag H.
Sir, 8 years and 6 months has already against the order of conviction of 10 years.
The order was passed by the Honorable Supreme Court on 3/11/2023.
Sir.
Paper book ready?
Yes, paper book ready.
Argue the matter. The paper book. Yes, 20B2C 10 years.
Sir, 10 years. Out of 10 years, he is already languishing in jail.
Argue merit argue. Yes.
My lord.
Where is your written note of argument?
No, that I have not prepared.
Prepare. Get ready. Since period the order of the Honorable Supreme Court at flag H, Mr. Niranjan Pandal and counsel appearing for the appellant submits that he will prepare a written note of submission along with citations by next week, put up this matter for hearing in the week commencing from 5th February 2024. Yes.
Item 62.
May plus not. As to the order dated 19/12/2023, the status report was called for. That is at flag mail.
Code order
19/12/2023.
Appellant number 3 ro.
Yes, madam.
And lagi.
Status report that is on the
status report call.
Status report. That is
has been has not availed the interim
yes,
bail.
madam. For that reason, lordship called for the
What do you want now?
Now, your lordship already granted the co-accused on bail by the order dated 11/12/2023.
11/12.
12, yes, madam. In IN number 1913 of 2020.
Because he was in custody for 8 years, 2 months, and 9 days.
The present appellant is in custody since 4/4/2016. It is reflected in the order dated 26/4/2023, my lord, kind of that's
24/6.
26/4.
Back karo.
Paragraph 3, second page. Paragraph 7.
So kete barse hala?
7 years, 9 months.
7 years, 9 months.
9 months or more months.
Yes, Mr. Hard, the Learned Counsel for the petitioner, Learned Counsel for the state. As per the order dated 19/12/2023, the Learned Trial Court has submitted the status report. Status report from which it reveals that the appellant has not availed the interim bail granted in his favor. Appellant number 3 lag diyo, Gandharva Kishan, है ना? Learned Counsel for the petitioner submits that the appellant was taken into judicial custody in connection with this case since 4/4/2016. And as such, he has undergone 7 years of 9 months of sentence out of 10 years.
Out of 12 years.
Out of 12 years imposed by the Learned Trial Court. And appellant number 1, Bhabesh Naik, who had undergone 8 years, 2 months of sentence, substantive sentence, has been released on bail by this court in IN number 1913 of 2023 as per order dated 11/12/2023. And therefore the bail application may be favorably considered. Learned counsel for the state oppose there is no serious objection to the grant of bail. Considering the submission made by the learned counsel for the respective parties, sentence already undergone by the petitioner in judicial custody, release of the co-appellant on bail, and absence of any chance of early hearing of the appeal in the near future, and keeping in view the ratio laid down by the Honorable Supreme Court in the case of Muhammad Muslim alias Hussain versus State NCT of Delhi reported in 2023 Live Law SC 260. I am inclined to release appellant number 3. Gandharva Kishan bail allowed. Yes.
Item 63.
63, Mr. Suman.
Item 64.
Please, your lordship.
Interim bail.
Interim bail वाले instruction.
कौन पाई?
Wife.
Health condition of so and so is not serious. She has not been advised for any kind of surgery. तो interim bail कौन पाई जीवे? Peruse the report furnished by the CIR exhibition application for interim bail. Land counsel for the on the ground of wife's ailment. The land counsel for the state has produced the report of dated 16/12/2023 of the Deputy Commissioner of Excise, SD Barampur, which indicates that the health condition of the wife of the petitioner is not serious and she has not been advised for any kind of surgery. The report is taken on record. In view of the report furnished, I am not inclined to grant interim bail to the petitioner. Stands rejected. Yes.
Item 65.
65, Mr. Sham.
My lord, lordship, on this matter through virtual mode, lordship. My lord, this is an appeal of 2018, and then application IA 1807 has been filed by us for the regular bail and suspension of sentence. Lordship, out of 10 years of imprisonment awarded by the trial court, 6 years he has completed.
Sentence
allegation of 10 years.
Sentence imposed 10 years.
Yes, lordship. And he has completed 6 years. 6 years.
कितने हेलानी? 6 years. 6 years.
Yes, lordship. There is no antecedents, lordship. He is a local person. He was on interim bail for 3 months. He surrendered on time. Other than that, there is sufficient merit to satisfy the twin condition of section 37, lordship.
IPO's 8 months लगा है के बेरा?
25 September को.
अच्छा. 6 years समझ नहीं रहा है.
Yes, lordship.
Our Mr. Shah Manohar Land Counsel appearing for the petitioner, who submits that out of 10 years of substantive sentence imposed by the Land Trial Court, the petitioner has already undergone 6 years of sentence, and he is a local man. There is no chance of absconding. There is no likelihood of the appeal being taken up for hearing at an earliest, and therefore the bail application may be favorably considered. Land Counsel for the state has produced the custody certificate from which it appears that the submission made by the learned counsel for the petitioner regarding the detention period of the petitioner is correct. Considering the submission made by the learned counsel for the respective parties, sentence imposed by the learned trial court, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, and keeping in view the ratio laid down by the Honorable Supreme Court in case of Muhammad Muslim, I'm inclined to release the petitioner on bail allowed sterilization of fine. Yes.
Obliged, my lords. Obliged.
Item 66.
Please, my lord. My lord, please see the last order. Also.
Last order is appellant submit that already undergone half of the substantive sentence. Custody certificate and
status of the victim.
And status of the victim.
Yes, she has already been married.
Appellant further submitted, okay. A with lekideva CRL number. Yes.
Item 68.
My lord, item 68. I pray, my lord, day after tomorrow, your lordship has had this matter, and because that 5 years has not been completed, for that reason, your lordship was pleased to adjourn this matter, my lord.
The land council for the petition appellant seeks for an adjournment. Put up this matter out of date. Yes.
Item 69.
May I please, your lordship, on behalf of Pavitra Kumar Paik, lordship. Lordship, we filed an IL, lordship, 290023, lordship, for the interim bail of the upland, lordship. Lordship, the trial court convicted the present upland, lordship, for 10 years, lordship. But now he is in custody from above 8 years, lordship. And the health condition of his parents is not good, lordship. His mother is not able to identify the people, and his father is paralyzed, your lordship.
What is the sentence imposed?
10 years RI and 1 lakh fine, lordship.
Yes, it is 10 years. And you are found guilty under section 20B2C, commercial quantity. Okay.
Lordship.
So
20
your
kgs.
period of detention is what do you say? 8 years.
8 years.
I have
He was
given the
arrested
question.
on 23rd.
I have given the question.
କେତେ ଦେଖୁଛି?
It is 7 years, 5 months.
He was on custody,
7
lordship,
years,
23rd of
7 years 4 months ହେଲେ ଏଇଟା custody certificate dated ଟା କେତେ?
Correct.
ହଁ ଏବେ କର ତାହେଲେ ଠିକ ଅଛି 7 ବର୍ଷ 4 ମାସ IA number so and so. This is an application for bail. What is your good name?
Sisir Paningrai.
Mr. Sisir Panigai, Land Counsel for the petitioner submitted that out of 10 years of substantive sentence imposed by the London Trial Court, the petitioner has already undergone 7 years and 4 months of sentence. There is no chance of early hearing of the appeal, and therefore the bail application may be favorably considered. Land Counsel for the state has produced the custody certificate, which also indicates that the submission made by the London Counsel for the petitioner is correct. There kahar pai file କରିଛନ୍ତି କୋଉ access ପାଇଁ?
Andrea Maji, lordship.
Okay. That is 2900. This is an application for bail filed by the appellant number 1, Andrea Maji. Hello? Interim bail. Considering the submission made by the Land Counsel for the respective parties, the petitioner, and sentence imposed by the London trial court period already undergone by the so and keeping in view the proviso essay to Muhammad Muslim case, bail is allowed.
Obliged.
Item 70.
When may I please, Your Lordship? Yes, my lord, the petitioner is custody since 7 years 4 months out of 10 years, and in the meantime, interim bail he has granted and he has also surrendered. The similarly proactive persons, my lord, has passed the order on the ground.
And is the custody certificate?
There was no direction. There was no direction.
अच्छी अपन पर এটা কি co-accused
name is Boilochan Bear.
No, no, এইটা কার?
এটা হচ্ছে কোয়াকিউস কপিলেস।
সেই কেস অফ কোয়াকিউস?
আଜ୍ଞା ସେଇ କେସ୍ 122 of 2016 ସିଟି କେସ୍।
ଆପଣଙ୍କ ପିରିୟଡ କେମିତି ଜଣା ପଡିବ?
ସାର୍ ମୋର
ମାନେ what is the detention period?
My detention period is 7 years 4 months. I am in custody since 16/9/2016.
ଏଇଟା କଣ ଯୋଉ 6/8/23 ର ଏଇଟା?
ଏଇଟା ଆଜ୍ଞା ଯୋଉଟା ଦେଇଥିଲେ ମୁଁ ସରେଣ୍ଡର କରିଛି
6/8/2000 ଆପଣ ବେଲ୍ ଯାଇଥିଲେ କି?
Granted on
8/5/2023.
2023. Order was on 3/5.
So 7 years ହେଇଯାଉଛି ଆପଣ?
7 ବର୍ଷ 4 ମାସ।
କେମିତି?
16/9 ରହିବି।
16/9/2016 ଗଲେ ଯେ
ଆଜ୍ଞା
ତାପରେ 3 ମାସ ପରେ ବେଲ୍ ଦିଆଗଲା ଆପଣଙ୍କୁ?
ହଁ ଦିଆହେଇଛି।
ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଇଥିଲେ ସେତେବେଳେ 3 ମାସ।
ଆଜ୍ଞା
ତାପରେ ପୁଣି ସେକେଣ୍ଡ ଟାଇମ ଗଲେ 3 ମାସ।
2 ମାସ 3 ମାସ
3 ମାନେ 6 ମାସ କଟିଯିବ ତା ଦେହରୁ।
3 2 5 ମାସ। ପ୍ରଥମଟା
6 ମାସ କଟିବ। ଖାଲି ବେଶୀ ବେଶୀ ହିସାବ କରିଦଉଛନ୍ତି କି?
ନାଇଁ ତାହେଲେ 7 ବର୍ଷ ହବ।
7 ବର୍ଷ କେମିତି ହବ? 17/9/2016 ଏଟା ହେଲେ 7 years 10 11 12 1 ବି ହଉନି 3 ମାସ ହଉଛି। 7 years 3 ମାସରୁ 6 ମାସ କଟିଗଲେ ଏଟା ଆସିବ 3 ମାସରେ 7 ବର୍ଷ ହେଲେ 6 ବର୍ଷ 9 ମାସ ହବ। Heard the learned counsel for the petition, learned counsel for the state. Learned counsel for the petitioner submit that the petitioner is in judicial custody since 17/9/2000. ये 17/9 रे?
ମୁଁ 16
17/9 ଅଛି ଆଗଟା ସେ 17 କରିଦିଅନ୍ତୁ। And he was granted interim bail for 3 months twice, and after availing the same is surrendered at right time. Further submits that one of the co-accused, who is an appellant in CRL number 202 of 2023, has been granted bail by this court in IA number 429 of 2023 as per order dated 22/8/2023. Files the copy of the order and also files the surrender certificate which is taken on record. And counsel for the state has no serious objection. Considering the submission made by the London Council for the respective party, the sentence imposed by the London trial for the period already undergone by the petitioner in judicial custody, and keeping in view the ratio laid down by the Honorable Supreme Court in case of Muhammad Muslim, I am inclined to release the petitioner on bail. Allowed.
Item 71.
May I please, Lord, address verification, my lord. I have given also fresh bail bonds.
Colleague,
I will pay some more time.
Aro saptah rakhibi.
Next.
All right. Mr. Tripathi, Land Counsel for the state, seeks some further time to ascertain the correctness of the address of appellant number 1.
ଆସିଯାଇଛି ସାର୍ ବୋଧେ
ନାଇଁ ତ କହୁଛନ୍ତି ଆଉ
ଭେରିଫିକେସନ ହେଇଯାଇଛି ବଟ୍
ଆଡ୍ରେସ୍ କହୁଛନ୍ତି ସାର୍ ଗୋଟେ ଆଉଥରେ ପୁଣି ଆରଥରକୁ
ସେଇଥିପାଇଁ ପରା କହୁଛନ୍ତି ଆସନ୍ତା ସପ୍ତାହ ରଖିବା ପାଇଁ।
ଆଡ୍ରେସ୍ ଭେରିଫିକେସନ ହେଇଯାଇଛି ବଟ୍ ସିକ୍ୟୁରିଟି ମାନଙ୍କର ସେଟା ଚେକ୍ ପାଇଁ ଯାଇଛି।
ଓ ଆଡ୍ରେସ୍ ଭେରିଫିକେସନ ହେଇଯାଇଛି, ସିକ୍ୟୁରିଟି ଆସିବ।
ଦିଟାକ ରିପୋର୍ଟ ମୋ ପାଖରେ ନାହିଁ। ଟକ୍ ୱିଥ୍ ଆଇଆଇସି ଗୋଳନ୍ତା।
ଆଚ୍ଛା, address verification has already been made, but security verification is awaited.
ସେଟା ଆସୁ ନେକ୍ସଟ ୱିକ୍ ରେ ଏକାସେ with
And the matter may be taken up next week. Put up this matter next week. Yes.
ମାନେ ସେ ପାର୍ଟଟା ସେ ଖାଲି ଓରାଲି କହିଛି, ଦେଇନି କିଛି।
ମୁଁ ଖାଲି ଲେଖିଦେଲି ଯେ ହେଇଯାଇଛି ବୋଲି କହିଦିଅନ୍ତୁ। address verification ହେଇଯାଇଛି, security verification is awaited. Next week. Yes.
Item 72.
May I please, Your Lordship? Lordship, petitioner files this IA for bail. So, petitioner, appellant convicted under section 20 BC of NDPS Act. The sentence was RI for 10 years and pay fine of 1 lakh rupees. Earlier, petitioner was availed 2 times interim bail, Lordship.
But one total period केते हला?
So, approximately 6 years, Lordship.
ଆଣିଛନ୍ତି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ?
ପ୍ରିଫର ନେକ୍ସଟ ୱିକ୍ ମାନେ ଦି ଜଣଙ୍କର ଆସିବା କଥା, ଜଣଙ୍କର ଆସିବା ଦି ଜଣ
ନାଇଁ ଏଇଟାରେ
ଦି ଜଣ ଅଛନ୍ତି ରବୀନ୍ଦ୍ର
ଜଣେ ଅଛନ୍ତି ଆଇଏ ରେ ଜଣେ
application.
this IE ସେ 2011 ସେ ରବୀନ୍ଦ୍ର ମାଥୁର।
This is only for appellant number 1.
ଦେନ୍ ରବୀନ୍ଦ୍ର ମାଥୁର ଆସିଯାଇଛି
ଆସିଯାଇଛି କେତେ?
5 years 10 months
5 years 9 months ହେଲେ ଆଉ ଦିଥର ଇଣ୍ଟରିମ୍ ବେଲ୍ ଗଲାଣି। ଲାଷ୍ଟ ଟାଇମ୍ କେବେ ଯାଇଥିଲା?
Last time lordship he was granted bail 18/11/2022
ସେଇଟା ଦେଇ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଏ କରିଦେଇକି ଦିଥର ଯାଇଛି ସରେଣ୍ଡର କରିଛି 3 ମାସ ଦେବେ ହେଲା। ୟେସ୍ ନେକ୍ସଟ
ବେଲ୍ ଫର୍ 3 months
3 months।
Item 73.
73 matter just one caption matter.
ଏଇଟା କଣ ଏଇଟା?
He has not released an interim lordship as granted as per instruction.
Alright, put up this matter in usual course.
Item 74.
May I please your lordship? In the last occasion, your lordship has a directive regarding the custody certificate, my lord.
କେତେ ସେଣ୍ଟେନ୍ସ କେତେ ହେଇଛି?
10 years, my lord.
କେତେ ଗଲେଣି?
He was on bail for a period of 3 months. Custody period is 6 years 3 months, my lord.
6 years 1 month
6 years 1 month 1 month is
2 months of 6 years 2
ਇਹਦੇ 3 ମାସ ଦେଇଛନ୍ତି। Yes, sterilization of time for them.
Item 75.
May I please? I am for appellant number 1, madam. Last occasion, your lordship was sought for the custody.
ଗୋଟେ ସପ୍ତାହ ପରେ ହଁ ଏଇପଟେ ଦେଖନ୍ତୁ ଏଇଟା ଫେବୃଆରୀର